proposal, not yet approved, is to put in your mouth a sort of lollipop sponge. Take a photo of that with your cell phone and send that to your doctor. If it lights up, you're positive. Or the university might send that saliva lollipop to a nearby laboratory, which could be a gene sequencing laboratory, which can deal with thousands of those samples overnight. That same process could occur at a middle school. It could occur at a factory. Of course, anyone testing negative one day can test positive the next, but such widespread screening of entire campuses, schools, or places of work will help identify those who are sick, trace down those who are exposed. That in turn should help persuade the rest of us to go back to school and back to work. In addition to more testing, I expect Dr. Fauci to talk to us about additional treatments that will be available to reduce the risk of death, and the administration's plan to do something that our country's never done before, which is to start manufacturing a vaccine before it actually has been proven to work in order to speed up the result in case it does work. Those vaccines, those treatments are the ultimate solution. But until we have them, all roads back to work and school go through testing. The more tests we conduct, the better we can identify those who are sick and exposed. Then we can quarantine the sick and exposed instead of trying to quarantine the whole country. Now, in my opinion, this will require millions of new tests, many from new technologies. Some of these will fail, but we only need a few successes to get where we want to go. That's why I said on Thursday that what our country had done so far in testing is impressive, but not nearly enough. First, squeeze all the tests we can out of current technologies. Next, try to find new technologies to help us contain the disease and persuade us to go back to work. Now, one other thing. This is a bipartisan hearing to examine how well we're preparing to go safely back to work and to school, and to determine what else we need to do in the United States Senate. Such an exercise sometimes encourages finger pointing. Before we spend too much time finger pointing, I'd like to suggest that almost all of us, the United States and almost every country, so far as I can tell, underestimated this virus, underestimated how contagious it would be, underestimated how it can travel silently in people without symptoms to infect other people, how it can be especially deadly for certain segments of our population, the elderly, those with pre-existing conditions, minority populations. Let me go back to the March 3rd hearing that we had in our committee on coronavirus. 6 weeks after the first case was discovered in the United States, a day when only 2 deaths were recorded in this country, I read at that hearing this paragraph from the New York Times 2 days earlier on March the 1st. They reported this: much about the coronavirus remains unclear, the Times reported, and it's far from certain, this is March 3rd, March 1, that the outbreak will reach severe proportions in the United States or affect many regions at once. With its top-notch scientists, modern hospitals, and sprawling public health infrastructure, most experts agree the United States is among the countries best prepared to prevent or manage such an epidemic. That was the New York Times on March 1. A lot of effort has gone into trying to make our country well prepared. Over the last 20 years, 4 presidents, several Congresses, in response to 9/11, bird flu, Katrina, Ebola, H1N1, MERS, passed 9 major laws to try to help get this country ready for what we're going through today. These laws stood up the Strategic National Stockpile, created an Assistant Secretary for Preparedness. It created incentives for the developments of vaccines and medicines that we're using today, strengthened the Centers for Disease Control, created BARDA, thanks to the leadership of Senator Blunt and Senator Murray for 5 straight years. We've significantly increased funding for the National Institutes of Health. All this was part of a shared goal. Democrats, Republicans, 4 presidents, several Congresses, to try to get ready for what we're going through today, whether it was known like anthrax or unknown like COVID-19. But despite all that effort, Even the experts underestimated COVID-19. This hearing is about how we improve our response to this virus as well as the next one. During the oversight hearing, I also intend to focus on, as I just said, the next pandemic, which we know is coming. What can we learn from this one to be ready for the next one? What can we learn from the fast tracking of vaccines and treatments that we're about to hear about that will make it even faster the next time? How can we keep hospitals and states from selling off protective equipment when their budget gets tight? How can we make sure Congress does our share of the funding responsibility? How do we provide enough extra hospital beds without canceling elective surgery, hurting other patients, and bankrupting hospitals? Whose job should it be to coordinate supply lines so that protective equipment and supplies get where they're supposed to go when they're supposed to go? What's the best way to manage the stockpile? My preacher once said, "I'm not worried about what you do on Sunday. It's the rest of the week that concerns me." I'm afraid that during the rest of the week between pandemics, we relax our focus on preparedness. We become preoccupied with other important things. Our collective memory is short. Just 3 months ago, this country was preoccupied with impeaching a president. Now that seems like ancient Roman history. Now, while this crisis has our full attention, I believe we should put into law this year whatever improvements need to be made to be well prepared for the next pandemic. If there is to be finger pointing, I hope they're pointed in that direction. We're fortunate today to have 4 distinguished witnesses who are at the heart of the response to the coronavirus. We're grateful for their service to our country. I've asked them each to summarize their remarks in 5 minutes. Then we'll have 5-minute round of questions from each senator. I've agreed we'll end our hearing about 12:30 after we have a full round of questions. Every senator will have a chance to have his or her 5 minutes. Senator Murray will then have an opportunity to ask the last question or to close the hearing, and I will then close the hearing. There will be other hearings to follow this hearing, like last Thursday's hearing, and senators may submit their questions in writing within the next 10 days. Staying at home indefinitely is not the solution to this pandemic. There is not enough money available to help all those hurt by a closed economy. All roads back to work and back to school lead through testing, tracking, isolation, treatment, and vaccines. This requires widespread testing. Millions more tests created mostly by new technologies to identify those who are sick and who've been exposed so they can be quarantined, and by containing the disease in this way, give the rest of America enough confidence to go back to work and school. For the near term, to help make sure those 31,000 UT students and faculty members show up in August, we need widespread testing. Millions more tests created mostly by new technologies to identify those who are sick and who have been exposed so they can be quarantined. By containing the disease in this way, give the rest of America enough confidence to go back to work and back to school. Senator Murray.
Well, thank you very much, Mr. Chairman. My thoughts are with you and your team right now as you try to navigate the same challenge so many in our country are worried about. We all wish your staff member a speedy recovery. And as everyone works to take appropriate safety precautions today, I'd like to thank not only our witnesses for joining us today, but also our committee staff for working to set up a safe format for members and witnesses and the public to participate in this hearing remotely. Families across the country are counting on us for the truth about the COVID-19 pandemic, especially since it is clear they will not get it from President Trump. Truth is essential so people have the facts so they can make decisions for themselves and their families and their communities. Lives are at stake. If the president isn't telling the truth, we must, and our witnesses must, and we're counting on you today. And families need us to take this opportunity to dig into the facts about where things did go wrong so we can finally get them on track. because the Trump administration's response to this public health emergency so far has been a disaster all on its own. Delays, missteps have put us way behind where we need to be on diagnostic tests and allowed inaccurate antibody tests to flood the market. Corruption and political interference have impeded efforts to secure desperately needed personal protective equipment and promoted dangerous, unproven treatments. And we recently learned that after experts at the Centers for Disease Control and Prevention spent weeks developing a detailed guide to help our communities understand how to safely reopen when the time comes, the Trump administration tossed it in the trash bin for being too prescriptive. But this is far from the first time this administration has silenced experts who were doing their job and putting public health first. The fact of the matter is, President Trump has been more focused on fighting against the truth than fighting this virus, and Americans have sadly paid the price. Since this committee last heard from these witnesses on March 3rd, we have seen over 900 deaths in my home state of Washington, over 80,000 deaths nationally, and the numbers continue to climb. Still, President Trump is trying to ignore the facts and ignore the experts who've been very clear we are nowhere close to where we need to be to reopen safely. My hope today is that we can cut through this and have a serious discussion about what is needed to safely open, how close we are as a country to meeting those needs, and how we actually get there. One thing that's abundantly clear, we need dramatically more testing. It is unacceptable we still don't have a national strategic plan to make sure testing is free, fast, and everywhere. That is why I fought to make sure our last COVID-19 package included an initial $25 billion testing fund and a requirement that the administration submit a plan by May 24th. And when I say a plan, I don't mean a PR plan. I mean a plan with specific timelines and numeric goals for supply and funding needs, one that actually addresses the issues we're seeing on testing capacity and distribution and disparities and building out our public health system, and makes clear to states and tribes and employers and the American people what they can expect and what the administration will do to keep Americans safe. But testing alone won't be enough to reopen our country. We still need far more personal protective equipment than has been available for our healthcare workers on the front lines. And we will need far more for other workers as we reopen. So we desperately need this administration to step up and get that equipment to states who are doing everything in their power to purchase supplies, but simply cannot get nearly enough. Because the reality is, unlike states, the federal government has the tools to actually fix the problem, if only the administration would use them. And we also need that equipment to actually work, and for the FDA to act promptly if it does not weeks later when people may have already been exposed. And just as importantly, we can't expect people to go back to work or to restaurants or to confidently send their kids to school if there isn't clear, detailed guidance about how to do that safely. Schools, from early childhood through college, need to know how to keep their students, their staff, and their educators safe. When should they wear masks? How do you run a school cafeteria or a school bus? And if they can't reopen classrooms, schools and families need to know we are working to ensure every student gets an education. Tools like online learning can only get us so far if we don't address the digital divide so that every student can access them. And even then, there will be learning loss that could deepen existing educational disparities among low-income students, students with disabilities, English language learners, and other vulnerable populations if we don't make sure they get equal access to resources and support. And of course, schools aren't the only workplaces we've got to be thinking about. We need to make sure that industries across the country know how to safely reopen and that people know their workplace is safe. Secretary Scalia needs to stop dragging his feet and do his job and have the Department of Labor set forward a rule that makes clear worker safety is not optional. Mr. Chairman, I hope this committee can hear about those critical issues from Secretary Scalia and Secretary DeVos, as well as other experts in the space in the days ahead. And this is especially important to protect workers and residents at our nursing homes and other congregate care facilities, where we've seen some of the most deadly outbreaks. And as the rash of outbreaks at meatpacking plants shows, this isn't just an issue for the healthcare industry, it is an issue for everyone. And just as we need a plan before we can start to reopen, we also need a plan well before we have a safe and effective vaccine to guarantee that we can quickly produce and distribute it on a global scale and make it free and available for everyone. So I'll be asking about our progress on those issues today. Today, safely reopening our country may be a ways off, and the administration's planning may be way behind. But there's still a lot that Congress needs to do. There isn't time to spare. Some, including the White House, say we've already provided enough economic relief. Well, my question to them is, what good is a bridge that only gets you to the middle of the river? We don't need to wait around to see if people need more help. We know they do. We need to work quickly on another aggressive relief package, and we need to make sure our priorities in that bill are protecting our workers, our students, and our families, and addressing this public health crisis, not bailing out corporations or protecting big business from accountability. People across the country are doing their part. They are washing their hands and wearing masks and social distancing and staying home. They need their government to do its part too. They need leadership. They need a plan. They need honesty. And they need it now.
Statute. I can't imagine that any of these subpoenas could come close, given how far back they look and how much of a dragnet they set up. These are the kinds of subpoenas that the court in Watkins said raised specific questions about whether they're really attempting to expose alleged wrongdoing as opposed to achieve a valid legislative end.
Secondly, following up on Justice Kagan's point about the future, on page 6 of your supplemental letter brief, you say that, quote, it is likely that civil litigation over the subpoenas.
So this is Justice Kavanaugh asking a question, and Kavanaugh is talking to Patrick Strawbridge. He's a Trump's lawyer.
This case is different because the subpoenas were issued to a third-party custodian, and there's an implicit assumption there that I just want to make sure of, namely that absent a court order, the private custodians plan to comply with the subpoenas. Even
I still like beer.
Or request them not to comply. Is that correct?
The recipients of these subpoenas have indicated that they consider it to be a dispute between the President and the House of Representatives.
I got to be quiet because Kevin Lee Daughter's still asleep.
Some sort of court
it's
order,
early here.
Regarding its validity, they feel obligated to comply. And this court in Eastland recognized
this is why I'm not a senator.
It's just not reasonable to expect in this situation the third-party custodian to risk contempt of Congress or other collateral consequences. And there needs to be a vehicle to allow for review, especially in this case where the President is suffering a personal injury.
Thank you, counsel. General Wall.
Mr. Chief Justice, and may it please the court.
I'd like to call the next witness. His name is Squee.
Congressional committees have targeted not the official records of the president.
They don't have witnesses in the Supreme Court, by the way.
Stretching back years before he was even a candidate for office. The potential to harass and undermine the president and the presidency is plain. It's not much to ask that before the House delves into the president's personal life, it explain in some meaningful way what laws it is considering and why it needs the president's documents in particular. The subpoenas here don't even come close. That creates two problems for the House. It can't satisfy any standards sensitive to Article 2 and the separation of powers, and indeed, as in Rumley and Watkins, this court should not decide a serious constitutional question the full House itself has not confronted.
Counsel, you spent a lot of time in your brief documenting that the purpose of these subpoenas was actually investigatory rather than legislative. And if that is a pertinent consideration, I wonder how a court is supposed to look at it. Should a court be probing the mental processes of the legislators? Should members of House committees be subject to cross-examination on why you were really seeking these documents?
No, Mr. Chief Justice, I want to be clear. I don't think any of that would be permissible. All we are saying is that you should review the subpoena on the basis of the contemporaneous objective record that is the basis for the legislative subpoenas themselves. So we have not in our brief turned to legislative statements. We haven't said that they should be able to get discovery into their mental processes or anything of the like. We have said that Chairman Cummings' memo shows the objective purpose is wrongdoing. But more important, I would just point to the mismatch between the breadth and duration of the subpoenas and their asserted purposes. I think with respect to all three, they don't match up with what the committees say they're doing if you look at the information they're seeking.
Thank you, counsel. Justice Thomas?
Oh, did they really, Stephen?
What if, following up on that?
So Nixon v. United States.
What if it was clear from those statements that you reviewed?
Oh, I guess it was U.S. v. Nixon.
Their intention was actually to remove the president from office rather than the sort of pretextual
Thomas is talking?
Reason that it is for legislative, pretextual legislative reasons.
But I do think if you
Thomas never asks questions.
But if you do, yes, I think they make clear that the subpoenas are not in aid of valid
That's
legislation.
That's a very good
the
sign.
Only enumerated power to which Congress has pointed here. The House has not relied on impeachment, and so you would simply just say the subpoenas are invalid. And to tie that into Justice Gorsuch's question earlier,
so it looks like Trump's team is arguing just that Congress can't subpoena stuff from the president unless they're writing a specific law.
I'm just saying, if you look at pages 46 and 54 of the red brief, and you look at what they actually say about their intended legislative proposals and then why they need the documents, it's paper thin. They don't give you any specifics on what they're thinking about doing.
The paper is
specifics on
paper
why they need the
thin.
Documents. And that's not an accident. It's not the product of carelessness or fault.
Couldn't come up with a better metaphor.
Because the purpose here is to expose wrongdoing, and the House has never really tried to substantiate why it needs these documents in service of its legislative powers.
Thank you.
Justice Ginsburg?
One must investigate before legislation. The purpose of investigation is to frame the legislation. You don't have the legislation in mind. You want to explore what is the problem, what legislative change can reduce or eliminate the problem. So, for example, the Ethics in Government Act, Congress may decide that it needs to beef up that legislation. It may also decide that for financial disclosure purposes, there should be disclosure of tax returns.
Yes.
So those are legislative
Justice Ginsburg
purposes.
For the prosecution?
Investigate to see if you need legislation of that sort. And then to impugn Congress's motive. I mean, even the policeman on the beat, if he stops a car and gives the reason that the car went through a stop sign.
Don't say frisk.
We don't allow an investigation into what the subjective motive really was. So here you're distrusting Congress
also true.
More than the cop on the beat.
Justice Ginsburg, I absolutely agree that Congress can investigate in service of what legislation might be needed. Our submission is much more modest. That when that inquiry involves the president, that you need a somewhat higher standard with respect to purpose, because the room for regulating the president is so much narrower than it is with respect to private parties. And on the need side, because of the danger of harassing and distracting and undermining the president.
There's basically argue the president gets a different set of laws, which is true, as we found out recently. But it's not supposed to be.
As against an ordinary litigant. And all I'm saying is that
which,
Congress
by the way, Stephen, is also something that came out of the Watergate scandal, which they want to use as precedents. But as you were saying, they don't want to use U.S. v. Nixon.
Assume, as I do, that for reasons set out in an opinion by Judge Griffiths, that we're not very good courts at deciding disputes between two powerful political branches. So it should be rare. But if it is in front of us, why not apply the standard that is ordinarily applied to every human being in the United States? in respect to, for example, grand jury subpoenas. Any human being in the United States, when he gets a subpoena, can go to a judge and say, Judge, this is overly burdensome.
To be fair, Trump is not a human being.
And here, if it's the president, the court's already written in Paula Jones 2 or 3 paragraphs of the kinds of things that a president has that are special need not to take his time, etc. But would you object to a decision of this court that says apply that, taking into account the special needs of the presidency, just like other human beings sometimes have special needs? They might be an emergency medical worker, etc.
I would, Justice Breyer, on 2 grounds. First, the court and the D.C. Circuit have rejected the analogy to grand jury subpoenas served by prosecutors. These are legislative subpoenas, not subpoenas issued by the executive branch for entirely different interests, and they trigger different concerns. These subpoenas need to be in aid of valid legislation, not as a prosecutor's subpoena to probe wrongdoing. And the second is, to take
but you can't know that.
I think what Justice Ginsburg was going to get at. We do think the analogy to Clinton v. Jones is actually helpful. The court there rejected an absolute immunity, but said the president was entitled to some special protections. And we're here saying the court should take exactly the same approach. We're not saying the House has no power to get at the records of a sitting president. We're saying that it needs to satisfy a heightened standard, because if it doesn't, these requests will become routine, and that weapon in the standing arsenal of the houses of Congress will, I think, be routinely deployed in a way that harms both the separation of powers and that undermines the presidency.
Justice Alito?
Could you apply the standard that you think is appropriate to the subpoena from the House Intelligence Committee?
Sure, Justice Alito. So there, the Intelligence Committee says that it's investigating foreign influence in recent elections, but the subpoena goes back to 2010. It doesn't link in any way to foreign transactions, and it targets only the president. I have no idea why one would serve a subpoena that broad, both in breadth and duration.
We were just discussing, Chris, only humans are allowed to argue before SCOTUS.
I would think the federal candidates more generally and more narrowly to foreign transactions and to more recent transactions. And there is nothing in the red brief that explains the mismatch. On the other side, the Financial Services Committee says it's investigating money laundering after the 2008 financial crisis, but its subpoena only goes back to the middle of 2016, and again, it targets the president. None of this makes any sense if what you are doing is in aid of legislation.
Justice Ginsburg referred to legislation concerning disclosure requirements that would apply to the president, and there's also mention of conflict of interest legislation that might apply to the president. Does Congress have the power to regulate the president in these ways?
I think it's very unlikely on the conflict of interest side, Justice Alito, that even the D.C. Circuit did not rely on that because of the serious constitutional questions it would pose if you disabled the executive from managing some part of the executive branch. I think the financial disclosures are the hardest, and I guess what I would say is if the House in its brief had explained with any specificity what it might want to do to the Ethics in Government Act and why then it needs the president's documents, we could have that debate. I think the room is probably narrow, but the United States is not saying there's no room. But we don't even get there because all they say is we might want to amend the EGA, CEG HR1, which was a bill the House passed before it even issued these subpoenas. And so it's very hard to sort of shoot at a target in the dark. I don't know what the House wants to do with any specificity, so it's hard to say whether that's valid legislation.
The House doesn't have to explain that. It has the power of legislation. It doesn't have to explain to you before it does the legislation what it's thinking about.
Congress investigates, A, it doesn't have a chance to determine what might be valid, and B, we don't have a chance then to look at an actual law and say it may or may not be valid. You're asking a court in the guise of a heightened review standard to speculate as to legislation that's not in effect yet. But I want to go back to the subpoenas at issue and their breadth. you note that the Intelligence Committee goes back 10 years, but I think it's fairly common knowledge that Mr. Trump, before he was president, was thinking about running for president for a very long period of time.
Since 2000.
Why is it that Congress can't believe that looking at long-standing relationships and how those relationships changed or didn't change is important to knowing what undue influence might be occurring?
Mr. Sotomayor, if it wants to do that, our submission is just a fairly modest one. It needs to do more than wave its hands about general purposes and say that the president would be a useful case study for prospective and generally applicable laws. Again, I'm not denying.
No, I'm not an attorney.
In what
but I have played one on TV.
Does any investigative
I should have been an attorney, which is what I've been told many times.
Than what was done here.
Attorneys make way too much money.
For private records.
And I have watched Billions.
Well, this particular question hasn't come up to the court before in a constitutional context. But in Nixon, of course, the prosecutor had to show demonstrated specific need. In the Senate Select Committee case, the Congressional Committee had to show...
Please, I
don't talk over the judge.
To executive privilege cases. I want you to go to papers that indisputably have nothing to do with Mr. Trump while he was a private person. They're not asking for these records post being president. They're asking for these records pre-being president.
I think that makes the problem worse, not better, Justice Sotomayor. They're targeting the personal life of the president before he was a candidate for office. That raises, granted, somewhat different, but deeply troubling and equally problematic constitutional concerns.
Does it, though?
Justice Kagan?
Mr. Wall, I'd like to go back to your use of Clinton v. Jones, because I had read that case differently. Of course, Clinton says that you're supposed to treat the president's requests with respect when the president says, like, I need a deposition scheduled at a different time, or can we have written interrogatories rather than a deposition? But the fundamental claim of presidential immunity or even presidential difference was rejected in that case. And I suppose what I'd like to know about your argument, I read your brief and I read the president's own brief, and no place do you make a case as to why these particular subpoenas place a particular burden on the president such that he will be prevented from carrying out his constitutional responsibilities.
Why?
And that's what I took Clinton v. Jones to be saying.
Why would you argue Clinton v. Jones when Clinton lost unanimously?
About burden on the president.
You're representing the president.
Are you making that kind of argument at all?
Well, yes and no. Not if what you mean by burden is sort of compiling and delivering the documents to the House. Yes, if what you mean by burden is what I think the Clinton v. Jones sense, which is harassing and undermining the president. Now, exactly these subpoenas, well, I mean, I think you have to look at it as
undermining the president. I mean, the point of some of those suits is presumably to harass and undermine the president, and the court let them go. Let them proceed.
Yeah.
And it said the only thing we're going to be concerned about is if you come into us and say, in defending those suits, you're going to be prevented from performing the responsibilities that we, the nation, need you to perform. Are you making an argument of that kind?
Yes. In the courts below, when the House was pressed on the limits of its theory, it said that probably it could not draw the blood of the president or read his teenage diaries. The power that they are seeking and the burden.
What about his teenage calendars? Let's go to Justice Kavanaugh for comment.
Will, I think, reshape and transform the balance of the separation of powers. So, yes, we are saying that these subpoenas, and certainly these subpoenas taken in the aggregate, once the House has this weapon, will harm and undermine the presidency of the United States. Not just this president, the institution of the presidency going forward.
He's got a good argument there. The president is really sensitive.
Counsel, I believe in earlier discussions with Justice Alito, you indicated that Congress might be able to regulate in the area of financial disclosures of the president. And that is one of the interests the House has asserted here. What more would you require the House to do to assert that interest? What would be enough in your mind to demonstrate the heightened need you suggest is needed?
I don't think it has to go provision by provision, Justice Gorsuch, or anything like that. But I do think it's got to describe the possible legislation with enough specificity to enable meaningful judicial review. So we know the president's required to disclose certain things from the Ethics in Government Act.
Well, let me stop you there. I'm sorry to interrupt, but let me stop you there. Let's say the House says we're considering legislation on whether to require presidential candidates to disclose their tax returns for a set number of years. Would that be sufficient? And if not, why not?
I think that might be, and then you'd have to look at what they were going after from the various campaigns. It wouldn't get you anywhere near these subpoenas or targeting the president, of course. But at least in your hypothetical, they'd be identifying,
except that's exactly what they're asking for.
Some specificity, what they were thinking about doing, and then then it would tee up what I think is the hard constitutional question of what's the space for Congress in regulating a constitutionally created officer like the president with respect to disclosures. And that's frankly a hard question. That's the hardest of all the possible legislation they've pointed to. I don't see how we can have that debate in this case because they haven't even enabled meaningful judicial review. And that's a fact that I think should cut against the House, not against the president.
What do lawyers sound like,
Justice
Martha?
Kavanaugh?
Thank you, Mr. Chief Justice, and good
Thank
morning,
you,
Mr.
give me
Wall.
just a moment.
Sure
It's Ralph
we
week,
touch
so
on
I'm
one
a
of
little
your
bit.
procedural arguments. You say that the full House needs to authorize the subpoenas.
Oh, Trump won't understand any of this.
The other side, the House argues that Resolution 507 did so. What's your response to that?
The response, Justice Kavanaugh, is that 507, if you look at its terms, it's both a rubber stamp and a blank check. It purports to authorize anything and everything that ever has been done or will be done by the committees. It falls short then even of the fairly meager resolutions in Rumley and Watkins, which at least described general purposes, general legislative topics. This gets back to my colloquy with Justice Gorsuch. And here we're talking about the president. So I know that 3 committee chairmen understood what they were doing. I don't think 218 members of the House have understood that they understand the gravity of the constitutional question they're teeing up. And so the court often requires a clear statement from Congress when the separation of powers is at issue. We'd say the same thing here. That's the cleanest.
This is the argument. Okay, House Res 507 basically says that the Congress has the right to subpoena the president.
In separation of powers
it's very
cases,
specific.
It
passed.
Justice Ginsburg
Jeffrey Wall is arguing, well, I'm not sure that everybody knew what they were passing. It's not how this country works.
Can you respond, and those dealt with legislative subpoenas, can you respond to those points about those precedents?
Yeah, so for the first 200 years of the Republic, there's nothing like this. The House's examples either didn't
There's never been anything like Trump.
Sorry to interrupt, but specifically Watergate and Whitewater.
Yeah.
So that's what I was coming to. I think the Watergate subpoenas were for official records, and obviously they were subject to a heightened needs standard. The Whitewater subpoena is the closest analogy. It's modern. It was never litigated, but I'll grant that subpoena looks very much like this one. I don't think that there's any historical precedent for it, and the concern, Justice Kavanaugh, again, if we go down this road and the houses of Congress can weaponize the subpoena power in this new way, that's going to sit in the standing arsenal for use against the president and any other constitutionally created officer. And I don't think it takes much imagination to know where that road will lead or that we will regret having taken it.
Thank you, counsel.
So 50 years ago is not precedent.
Mr. Letter?
Yes. Mr. Chief Justice, and may it please the court, I would like to jump right in and address some of the very key points that have been made
from Law and Order.
by my friends here.
At Law and Order SUV,
Mr.
right?
Wall, my very good friend, Mr. Wall, said that the legislation here doesn't match up. Mr. Wall referred the court to the wrong pages of our brief. If you look at pages 17 through 36, you see that we discussed in great detail the purposes of the investigations and the subpoenas, and indeed the D.C. Circuit said that, in telling terms, the House has put legislation where its mouth is. We have specifically provided bills. Mr. Wall said that the full House did not confront the subpoenas. Page 241 of the appendix, I refer you to, where the House specifically referred to these very subpoenas, these specific ones. And I don't think Mr. Wall really meant to say that the 218 members of the House did not know what they were doing when they passed that. That obviously is not a valid argument to be made. Then we turn to something that came out in answer to Justice Sotomayor's question. Remember that key records here, some of the key ones that we want, are ones that President Trump has not even seen. We want records from third-party business entities that their analyses of for instance, requests for loans. So these are documents that there's no privacy interest in, no constitutional liberty interest, etc. Next, we do have limiting principles. The House very much does. This court's precedent set those. Must be pertinent to a legislative purpose, can't violate constitutionally protected liberty interests or privileges, can't undermine the president's ability to carry out his responsibilities.
Mr. Letter, let's talk about the standard you propose. The quotes in your brief is that it concern a subject on which legislation could be had. Could you give me a plausible example of a subject that you think is beyond any legislation that Congress could write?
Good question.
Your Honor, I think the best I can do is refer you to the court's decision in Kilbourne, where the court there said that Congress didn't seem to put forward any possible legislation there. It had to do with bankruptcy proceedings that Congress was looking into.
Ask and answer.
Do you think bankruptcy proceedings is a subject on which legislation could not be had?
Obviously, bankruptcy could be, but in the Kilbourne case, this court thought that no such reason had been put forward.
Letter's good.
But no, Congress's legislative authority is extremely broad, especially because of its appropriations.
Well, that's what I'm suggesting, that your test is really not much of a test. It's not a limitation. And it doesn't seem in any way to take account of the fact that we're talking about a coordinate branch of government, the executive branch. Do you have any alternative to that limitless test that would take account of the fact that you're dealing with a coordinate branch of government?
Yes, I do.
The Bill of Rights.
By the way, the test that I'm referring you to was the test that this court had set about pertinent to a legislative purpose. But,
it's a good argument.
Your Honor, it's what this court said in Nixon versus GSA and a number of other cases. Congress, there would be a limit if Congress is interfering with the president's ability to carry out his Article II functions. No such claim has been made here, nor obviously can it be made.
Justice Thomas?
Yes, thank you, Chief Justice. Mr. Letter, I'd like you to discuss...
Watch the Republicans pass an amendment saying that the president's taxes can't be looked at.
Legislative subpoena power is implied, or how we arrive at that power. Because I think that's part of why we're wandering around in the wilderness trying to determine what standards we are to use.
Your Honor, this court has explained in quite a few cases, I think Watkins, Barenblatt, others, that the Congress's legislative power...
He's just making up names.
Investigative power, which stems from the British Parliament's power, is an obvious and integral part of legislation. We obviously can't have Congress passing legislation in ignorance. And this court has said, for instance, most recently in Franchise Tax Board, that just because a power is something to be implied doesn't mean that it's not important. For instance, this court's power of judicial review, that's nowhere mentioned in the Constitution. So the power to investigate is...
he's getting all Marbury versus Madison on their ass.
Legislative power
is that old enough for Wall? Are we done?
I'm sorry, Your Honor, I'm not coming up with something right now off the tip of my tongue.
Okay. Can you give me the earliest example you have of Congress issuing a legislative subpoena?
Does it go back before Nixon?
Congress investigated the St. Clair expedition. It didn't actually issue a subpoena in that case, but it's equivalent of the time. And President Washington consulted with his closest advisors and decided to provide Congress with every single thing that it requested. So that was just several years into
What's the first example of Congress issuing a legislative subpoena to a private party for private documents?
I'm sorry, Your Honor, the Watkins decision has a lengthy discussion of that. I don't have off the top of my head the very first one, but my memory is that this court describes that in great detail in Watkins.
Thank you.
Justice Ginsburg?
The concern has been expressed that Congress could be using this subpoena power to harass a political rival. So what is your answer to, what is the principle, the limiting principle that would say legitimate legislative purpose, yes, looking toward enacting a law, but not to harass a president from the opposing party?
Two answers, Your Honor. First is this court's decision in McGrain, which is extremely important here. Now, McGrain was not seeking papers of the president, but there the lower court struck down, said the subpoena was no good, the congressional investigation was no good because it was inspired by politics. This court absolutely and flatly and unanimously rejected that as a reason that it couldn't be done. And then the other is Clinton versus Jones.
Yeah.
The court said if there is harassment,
anybody, every American has the right to be harassed.
Take care of that, and that's the answer to the Justice Department's entire brief. There is no responsible claim here that all that's going on is harassment, and if there is, this court has said, we're here.
Thank you.
Justice Breyer?
Thank you. In respect to the authorization, was there proper authorization by the full House of the legislative subpoenas? 2 points. One, Roomley says, look at the subpoena and its authorization as of the time the subpoena was issued. Here, perhaps, the time that it was challenged first, before the later authorization in the full House was passed. 2, compare it with the Senate Select Committee on Presidential Campaign Activities v. Nixon. Look at the authorization. The authorization there is highly detailed, highly specific, and it suggests they could go after the information held by any person, presumably including the president. This authorization, which came after the challenge, in fact, writes a pretty blank check for anything without detail. Now, those are arguments made by the other side. I'd like to hear what you say.
Thank you, Justice Breyer. Several responses, and I'll try to be quick. First, McGrain, this court said very, very clearly, you don't just look at the authorization. There was no authorization there. Second, yes, Resolution 507 is in part broadly worded, but it is extremely specific in its third whereas clause. Right there on page 241, it refers to these very specific subpoenas. And in addition, authorization is much different now in the modern Congress. The modern Congress has authorized committee chairs has authorized committees to issue subpoenas, and those committees then have, in general, delegated that authority to its chairs. So the modern Congress, there clearly
those are Republican rules, by the way,
to committee chairs to issue these subpoenas. And as I said, if there's any doubt at all about that, the full House ratified these very specific subpoenas.
It's a good point.
Before or after Roomley? I mean, before or after they were issued and challenged?
This is after they were issued and challenged. The issuance, as I said, is authorized by House rules, which this court has said it will not examine. And
I would think that'd be even more relevant.
Because there were arguments made, the full House said, oh, no, we authorize these exact subpoenas. We ratify.
Yeah, the subpoenas were written. They were challenged in court. And then the House got together and voted and said, no, this is what we want.
Of the petition appendix.
Thank you.
Justice Alito?
Hard to say which way Breyer's going on this.
Somewhat baffled by your answer to Justice Ginsburg about the use of congressional subpoenas for purposes of harassing a president. Your final answer was the courts can take care of that, but that's the issue here, whether something should be done to prevent the use of these subpoenas for the harassment of a president.
Clinton v. Jones.
Could you explain what you meant?
Absolutely, Justice Alito. This court in Clinton versus Jones and in other cases like Nixon versus GSA has said we are here to protect the president if there is harassment from Congress or private individuals. And here, there clearly, though, is, we think, valid legislative purposes. The four courts below all found that there was.
I don't want to cut you off, but I have very limited time. So your
answer
is that the protection against the use of a subpoena for harassment is simply the assessment whether the subpoena is conceivably is relevant to some conceivable legislative purpose.
Correct. That's what the court has said, but also, again...
Well, the party has to have
Jones
standing.
And Nixon versus GSA.
And that's not much protection. In fact, that's no protection, isn't it?
It is protection, Your Honor, if what Congress is doing is interfering with the president's ability to do his job. These subpoenas are to private parties. The president does not need to do anything.
When you talk about interfering with the president's ability to do his job, do you mean this is going to take up too much of his time? Or does that include
there's presidenting, there's golfing.
The use of subpoenas solely for harassment and political purposes?
Your Honor, if they were solely for harassment, then they wouldn't meet the standards of they have to be pertinent to a legislative purpose. So I think the combination of all of those provides ample protection.
And Jones was not, and they still passed it.
You were not able to give the Chief Justice even one example of a subpoena that would not be pertinent to some conceivable legislative purpose, were you?
As I said, Your Honor, that's correct, because this court itself has said Congress's power to legislate is extremely broad, especially when you take into account appropriations.
Well, so the end result is that there is no protection whatsoever, in your view, and maybe this is the correct answer, but in your view, there is really no protection against the use of congressional subpoenas for the purpose of preventing the harassment of a president, because the only requirement is that the subpoena be relevant to a conceivable legislative purpose, and you can't think of a single example of a subpoena that wouldn't meet that test.
No, Your Honor, because remember, there may be constitutionally based privileges or things like executive
the Bill of Rights.
Executive privilege.
Well, there might be constitutionally based privileges. Which constitutionally based privileges apply to a subpoena for records in the hands of a third party?
There could be, Your Honor.
What are they? Would you name one?
Oh, well, it seems to me executive privilege could enter in. State secrets privilege could enter in, depending upon the specific circumstances, Your Honor.
Let me ask you one more thing, if I can, and there's time. Are there any limits on using
emergency powers
records as a case study relating to the need for legislation? So, for example, if the salary and the net worth of a future president before election was that of a person who would be regarded as middle class, and Congress says, we want to study possible revisions of tax laws and the provision of services to members of the middle class, so we're going to subpoena all available information about the assets, income, expenditures, and services obtained by this sitting president and his family for purposes of considering that legislation. Would that be permissible?
It certainly could be, Your Honor. So here, that's a very good question. Here, remember, the Financial Services Committee is doing an extremely broad investigation of a financial services sector, and there's massive public reporting that before he became president, President Trump's personal records and his businesses and his family have been heavily involved in those very activities. And we're investigating numerous other banks and individuals having nothing whatsoever to do with the president. This is part of a much larger sector-wide, industry-wide investigation, and President
Justice
Trump is...
Sotomayor?
Counsel, we have said that personal records, with the aim of making the president a case study, threatened to run afoul of this court teaching that there is no congressional power to expose for the sake of exposure. And the other side points to some hypotheticals that are troubling. The president's transcripts, simply to pass on educational reform legislation, or subpoenas of his personal medical records, simply to enact general health care reforms. Tell me what we say to ensure against those hypotheticals and against a proposed subpoena that might be just for the sake of exposure.
Your Honor, a couple of answers. One is, yes, you said just for the sake of exposure is no good, but this court said that exposure involving government activities can be. Pertinence.
President's in charge of the IRS. It's in the executive branch.
Legislative purpose.
A perfectly valid argument.
The Intelligence Committee, there's an obvious need to focus on the president's financial records to determine if the president is subject to foreign leverage. It's obvious that it ties in with that legislative purpose. So pertinence.
Let me put this. I'm sorry to interrupt you, but
I mean, if they were just going to harass the president, they could ask for the transcripts.
Of what laws are possible, I can see the argument on conflicts of law, but aren't there already a lot of disclosure laws in place? How could this investigation help improve those or change those?
I assume what Your Honor is referring to is disclosure laws by the president, and so we would have to look to see exactly what the Oversight Committee was looking at. Do we need better laws about conflicts of interest? Do we need better laws about, for example, a president dealing in contracts with government agencies? The Congress could limit government agencies' ability to enter into or keep contracts with elected public officials. In addition,
your medical records are not going to lead it to a conflict of interest. Your transcripts are not going to lead to a conflict of interest. The investigation of the president's taxes could lead to ethical laws, new legislation, specifically to deferring conflict of interest.
Yes, Your Honor,
from a forthcoming or sitting president.
And they are discussed in great detail by the Second Circuit and the D.C. Circuit. So those were
honestly, though, not that we care about conflict of interest.
Justice Kagan?
Good morning, Mr. Letter. In talking to the Chief Justice,
she looks happy.
About the limits on congressional
Why don't they?
Power,
they should force them to show their real faces right now on Zoom. I mean, they're wearing pajamas already.
Carrying out his constitutional functions. Is that right?
Your Honor, there would have to be a balance there.
Okay, but that's what we should be looking to. And then you said no such claim has been made or could be made. And I also took the briefs not to be making that claim, that this subpoena would impair the president in carrying out his constitutional functions. But Mr. Wall told me that he was kind of making such a claim because he thought that this subpoena would undermine the president in his job. And I guess I would like you to comment on that.
Your Honor, it's fascinating because I wrote a note specifically on that. That argument was not made in the Justice Department's brief, to my knowledge, anywhere. My friend Mr. Wall mentioned it here, but there's no way that this could interfere with the president because he doesn't have to do anything. This is a subpoena to two banks and an accounting firm. And as I said before, in fact, some of the key documents we want, the president probably has never even seen or doesn't even know that they exist. We want to know banks' analyses of his request for a loan, internal bank analyses. But yes, Your Honor, that argument was not made in the briefs.
Okay, and if I could get you to talk about the history that some of your colleagues have talked about, what do you think the history shows us with respect to this issue?
Your Honor, very briefly, what it shows is ties in with a key principle of law that this court has said of constitutional interpretation. History can help inform what the Constitution means. There's a lengthy history of presidents either voluntarily or not voluntarily complying with requests for information by Congress. And we went through presidents Washington, Jackson, Buchanan, Grant, and in more modern times, Nixon, Carter, Reagan, and Clinton, all complying with, in various ways, either voluntarily or not. For instance, in the Nixon case, Nixon voluntarily provided certain tax returns. He didn't provide all of them. Congress then got more pursuant to statutory authority, like a subpoena, of President Nixon and his family's tax returns. I don't think that either the Justice Department or Mr. Trump answered that hypothetical. History really matters here, and it shows that the arguments being made here by President Trump are astonishingly ask you to ignore a massive amount of history.
Thank you.
Justice Gorsuch?
Okay, we're going to Fauci. Thanks for the heads up, guys. I've got him on the other screen. He's talking to Bernie on that screen. But yeah, we're definitely going over to Fauci. Let's make this work. Give me a link. Okay, we're going to keep this page. I'll make it small. We're going to pull this up and we can rewind a little bit. I should be able to rewind. Yeah, should be on Newsroom right now. Let's go to the CNNs.
This is CNN Breaking News.
And welcome to The Lead. I'm Jake Tapper. In the next hour, President Trump will take questions from the White House. He's eager to project confidence that he is in control of this coronavirus crisis. No, this is from yesterday. Come on, YouTube TV.
Get it together, Kevin. Live. There we go. Okay. Are they broadcasting it? They sure are. Let's go to MSNBC. And we're going to go back a little bit for Fauci here.
So my approach towards the we don't fully understand all of the ramifications. Senator Sanders, if it's
here we go.
That we don't fully understand all of the ramifications of the COVID-19 epidemic. But let me ask Dr. Fauci a few questions, if I might. For a start, the official statistic, Dr. Fauci, is that 80,000 Americans have died from the pandemic. There are some epidemiologists who suggest the number may be 50% higher than that. What do you think? I'm not sure, Senator Sanders, if it's going to be 50% higher, but most of us feel that the number of deaths are likely higher than that number because given the situation, particularly in New York City, when they were really strapped with a very serious challenge to their healthcare system, that there may have been people who died at home who did have COVID, who were not counted as COVID because they never really got to the hospital. So in direct answer to your question, I think you are correct that the number is likely higher. I don't know exactly what percent higher, but almost certainly it's higher. Dr. Fauci, let me ask you this. In the terrible pandemic of 1918, the virus exploded in the fall. It came back with a vengeance. are we fearful that if we don't get our act together, as bad as the situation is now, it could become worse in the fall or winter?
Well, Senator, thank you for that question. It's a frequently asked question, and I think that possibility does exist. However, and the reason I say that is that when you talk about will this virus just disappear, and as I've said publicly many times, that is just not going to happen because it's such a highly transmissible virus. And even if we get better control over the summer months, it is likely that there will be virus somewhere on this planet that will eventually get back to us. So my approach towards the possibility of a rebound and a second wave in the fall is that A, it's entirely conceivable and possible that it would happen, but B, I would hope that between now and then, given the capability of doing the testing that you've heard from Admiral Giroir and the ability of us to stock up on personal protective equipment and the workforce that the CDC under Dr. Redfield will be putting forth to be able to identify, isolate, and contact trace, I hope that if we do have the threat of a second wave, we will be able to deal with it very effectively to prevent it from becoming an outbreak, not only worse than now, but much, much less.
Okay, let me ask, we've heard a lot of discussion about vaccines. Obviously, everybody in Congress and in this country wants a vaccine. We want it as quickly as possible, as effective as possible. Let me ask the Honorable FDA Commissioner, sir, if, God willing, a vaccine is developed, and if we're able to produce it as quickly as we all hope we can, I would imagine that that vaccine would be distributed to all people free of charge, or make sure at least that everybody in America who needs that vaccine will get it, regardless of their income. Is that a fair assumption?
Senator, I certainly hope so. FDA is very committed to making sure that all populations in the United States, including those most vulnerable, are included in the clinical trials. And
well, that's not what I'm asking. What I'm asking is, if and when the vaccine comes, it won't do somebody any good if they don't get it. And if they have to pay a sum of money for it in order to profit the drug companies, that will not be helpful. Are you guaranteeing the American people today that that vaccine will be available to all people, regardless of their income?
Sir, the payment of vaccines is not a responsibility of FDA, but I'm glad to take this back to the task force. I share your concern that this needs to be made available to every American.
Does anybody else want to comment on that? Mr. Doral, do you think we should make that vaccine, when hopefully it is created, available to all regardless of income? Or do you think that poor people and working people should be last in line for the vaccine?
I'm sorry, Senator, were you asking me?
Yes, I was, sir. Yes, I was.
No, my office is one of the offices committed to serving the underserved, and we need to be absolutely certain that if a vaccine or an effective therapeutic or preventive is available, that it reaches all segments of society, regardless of their ability to pay or any other social determinants of health that there may be.
Good. So when you're telling the American people today that regardless of income, every American will be able to gain access to that vaccine when it comes?
They should gain access to it. I don't control, I think
you represent an administration that makes that decision.
I will certainly advocate that everyone is able to receive the vaccine regardless of income.
Nobody wants to hear me, Greenroom.
Let me just switch gears.
Senator Sanders.
I'm sorry. All right. Thank you, Mr. Chairman.
Just a moment. I have another question for Blurry Kiefer Sutherland.
And it's hard to see the time clock, but if we could stay as close as possible, 5 minutes, then all senators can get their questions in. Thank you, Senator Sanders. Senator Burr.
Thank you, Mr. Chairman, and thank our witnesses today for what you've done for the people in this country and their safety and people around the globe.
Is that God's voice?
Fauci, because you've been in the task force and at a majority of the press conferences, has anybody in this administration ever asked you or any member to take the foot off the gas of trying to find a cure or any type of countermeasure?
Bizarre.
No, Senator, not at all. As a matter of fact, we at NIH, as you know, have been right from the very beginning, put our foot right on that accelerator in every aspect, including the development of vaccines and therapeutics. And as I described
Fauci
in my
reads
opening
books.
statement, we actually
He looks
started
smart.
that in January, literally days after the virus was known and its sequence was published.
MSNBC,
so, no,
get it
I
off.
have never been told by anyone to pull back on the development of any countermeasure or any basic and clinical research project that we've been involved in.
Thank you, Dr. Fauci. This question is for Dr. Redfield. Dr. Redfield, we have authorized in this committee and appropriated.
We're going forward on this.
And we'll focus the unbelievable amounts of money that we've provided for you that they will
real
show
time now.
some benefit to the American people. Dr. Fauci, let me come back to you.
Yes.
This is one of the fastest development timelines we've ever seen for vaccines. And the American people and hopefully people around the world will be the beneficiary of what you find and the eventual licensure of that product.
Do you guys want me to talk about my worries with the vaccine?
With this particular virus,
what's different about this virus that could make it really difficult to, or has that been sort of discussed in the media? I haven't heard anyone talking about it.
Please do. Dr. Fauci.
Yeah, thank you very much, Senator Burr. Well, there are a couple of things that I think are inherent in all vaccine development. First of all, there's no guarantee that the vaccine is actually going to be effective. As you well know, because we've discussed this many times in the past, that you can have everything you think that's in place and you don't induce the kind of immune response that turns out to be protective and durably protective. So one, the big unknown is it will be effective. Given the way the body responds to viruses of this type, I'm cautiously optimistic that we will, with one of the candidates, get an efficacy signal. The other thing that's an unknown that's of concern, but we'll be able to get around that by doing the tests properly, is that
you get a bandit there? Are they being robbed?
Namely, there have been
quick turn the stagecoach around.
Two in particular, dengue and respiratory syncytial virus. When the vaccine induces a suboptimal response, and when a person gets exposed, they
Who's
actually
the Senator
have
Kane? Why haven't we ever heard of him
pathogenesis of
before?
the disease, which is always worrisome. So we want to make sure that that doesn't happen. Those are the two major unknowns. Putting all those things together, Senator Burr, I still feel cautiously optimistic that we will have a candidate that will give some degree of efficacy, hopefully a percentage enough that will induce the kind of herd immunity that would give a protection to the population at home.
Dr. Hahn, anything to add to that?
No, nobody cares. So one of the things about this virus is it's causing something called a cytokine storm, which is your in some cases, the patient's immune system, for no reason it seems, the immune system starts attacking their own body. So the liver and other vital organs start being attacked by the person themselves, and then you have to treat that with anti-immuno. Basically, you have to suppress the immune system of the patient while the immune system is trying to fight the virus. And no one yet has figured out why some patients have the cytokine storm, some don't. But when you put the vaccine into somebody's body, even though it's theoretically a dead virus, if they're going to go that direction with the vaccine, which is the most likely of candidate, which is most vaccines, but again, I'm not a doctor, you have to figure out why some patients react to it, even though it's a dead virus. Are you going to end up with a promising vaccine that then produces that? That's why we have to make sure this thing is safe before putting it out to the general population. Because it took us a good month and a half to figure out how to treat patients. And I think it was right here in Seattle. At least that's one of the articles I read, where they figured out, hey, we got to treat both of these things going at the same time. And are you going to produce a vaccine? Basically, we have to figure out why that's happening to some people and not to other people. That's my worry about the vaccine.
Yes, sir. Thank you for the question. The obstacles from a regulatory point of view, I think, are being met by the approach that's being taken out of HHS.
So, Lizzie,
and led
you're
by
pretty
Peter
much
Marks,
you're the
and
guinea
that is
pig.
A common preclinical development pathway so that we can appropriately assess one vaccine against the other And
it's
then
so
a
sad
master
that Stephen Hahn
protocol
died
that
and is
allows
now
for
broadcasting
a
from
common
heaven.
control
But it gives
group
us hope.
and an assessment of very common endpoints. That'll let us be as efficient as possible for the development of vaccine. We will evaluate approximately 10 candidates preclinically, and then in the phase 1 and phase 2 studies, and then take 4 to 5 into phase 3 studies in this HHS effort. So I think those are the obstacles that can be broken down to speed the development, but also allow us to ensure safety and effectiveness.
Mr. Chairman, yesterday the state of North Carolina started to publicize the recovered numbers, those individuals who had coronavirus but have recovered. It's my hope that nationally we will start reporting the recovered numbers. I think that's important for the American people.
We do.
I yield back.
We do
Thank
already.
you, Senator Burr. Senator Casey.
They're fully available.
Mr. Chairman, thank you for the hearing, as well as the Ranking Member Murray. Mr. Chairman, I wanted to start today
Sure,
with,
but think about the
question regarding
333
nursing
Americans that don't have the
in
coronavirus.
particular, across a state like ours, we've had,
Why isn't anyone
as you
talking
might know,
about
a high
them?
number of cases in Pennsylvania. At last count, over 57,000 cases. The number of deaths have gone above 3,700. And of course, a lot of those deaths are in nursing homes. We're told that nationally, more than a third, as high as 35% of all deaths have been in nursing homes, either the death of a resident of a nursing home or a worker. So I'm going to start today with a question for Dr. Redfield. Doctor,
Are you on
we
daily
consider
meds then,
this
Lizzie?
challenge in our long-term care facilities, when we look at the number of deaths in nursing homes, I think a lot of families want basic transparency.
Casey's all, give me enough books so that I look smart, but not dorky.
I sent you a letter dated April the 2nd. It was directed to you as well as the administrator of the Centers on Medicare Medicaid
Some of them
Services,
combined. You're right, Chris.
Seema Verma.
Depending on how you look at
we
it.
asked for basic information about what the administration was doing to track the outbreaks in nursing homes, to provide
Marfa, where are you in New York? Where are the Blue Angels?
Information to families and their and residents, the families of residents in nursing homes, certainly to the workers as well as to the community and public health professionals. Now,
frickin' senators, just ask the question. You complain that you don't have enough time, and then you ask a 16-minute question.
You didn't give us any information about the timeline. These families need this information. And now we're told by the CMS administrator, after pressing her, as Senator Wyden and I did, that this information may not be available until the end of May. I need to hear from you today. Why has there been a delay, a 3-month delay in basic information that families and people within a community need about the outbreaks in nursing homes, the number of cases, what is happening in nursing homes? Tell us when we're going to see that information.
I hope he just says incompetence.
Well, thank you very much, Senator. And you've highlighted one of the great tragedies that we've all experienced together.
You didn't have to say thank you.
The long-term
he
care
called the failure of the
facilities
test a success
have been
because, you know,
particularly
quality
hard hit,
control.
By this pandemic.
I might even have that
several
video,
things,
but I'm not going to play it.
I know that, again,
I do have that
CMS,
video.
who has oversight, several things have been done, and I can get back to you in terms of where they're at in terms of activation, but clearly all nursing homes now are required to report cases in either their individuals that are patients there or
That's true, Chris. I mean, at some point the elderly are going to die. So,
secondly, I know that FERMA has put a policy in place that all nursing homes are required to notify their members of that nursing home of the existence of COVID in that.
So it's like a hostage video where he's looking at the guy holding the gun at his head.
Verify in terms of
he starts a sentence
if that's operational as of today or
okay. I
will get back to you with that. One of the most important we have decided as we talk about the key in reopening, as Tony mentioned, we need those symptomatic cases. We need to be able to do the contact tracing. But the other thing that we really need to do is to do surveillance, because this virus does appear to have a high propensity for asymptomatic
I want to know what all this
infection,
is.
which means our traditional ways of
This is a
identifying
Jesus
cases
calendar over
is
here?
going to be blunted. And so we're developing a national surveillance system, and first and most important,
Look at the camera.
is to do comprehensive surveillance in all the nursing homes in the United States.
And now he's looking at the other captors. There's several of them in the room, clearly.
In partnership with the state and local territorial health departments. I think HRSA is going to have the responsibility to do it within the inner city clinics that are selected, and the Indian Health Service for the Indian Health Service clinics. But this is critical. We get in front of this and do comprehensive surveillance of everybody in these nursing homes. We've also done, aggressive outreach in all of them in enhancing infection control procedures, et cetera. CDC's been out.
It's critical that we get in front of this 3 months later.
Are
we going to lean into it? Can we lean into it at least?
But I'll get back to you in terms of the time. I'm pretty confident it's already operational, but I need to double check just to make sure, because I know SEMA has announced that they're all reporting to CDC now any infection in workers or patients, and that they are required now to notify other members in the nursing home as well as family members of them when COVID is in one of those.
And Mr. Chairman, I just have one question for Dr. Fauci.
Excellent.
Doctor, I wanted to ask you, in your testimony earlier in response to a question by Senator Murray, you outlined a basic concern you have with regard to states reopening. Can you restate that for us?
Yes. Thank you, Senator Casey. Yes. My concern is that if states or cities or regions, their attempt, understandable, to get back to some form of normality, disregard to a greater or lesser degree the checkpoints that we put in our guidelines about when it is safe to proceed in pulling back on mitigation. Because I feel if that occurs, there is a real risk that you will trigger an outbreak that you may not be able to control, which in fact, paradoxically, will set you back, not only leading to some suffering and death that could be avoided, but could even set you back on the road to trying to get economic recovery, because it would almost turn the clock back rather than going forward. That is my major concern, Senator.
Thank you.
Thank you, Doctor. Thank you, Mr. Chairman.
Thank you, Senator Casey. Senator Paul.
Dr. Fauci, scientists have shown that
are you ahead of us?
That are infected
Lizzie?
with COVID-19 cannot be
Are you
reinfected.
watching on another source?
Several studies have also shown that plasma from recently infected coronavirus patients neutralizes the virus in lab experiments. In addition, infusion of convalescent plasma is based on the idea
Paul Rand
that
coming from the other side?
coronavirus patients are developing immunity and that it can be beneficial as donated.
Go
Studies
to the
show that the
light.
recovering COVID-19 patients, from the asymptomatic to the very sick, are showing significant antibody response. Studies show that SARS and MERS, also coronaviruses, induce immunity for at least 2 to 3 years. And yet the media continues to report that we have no evidence that patients who survive coronavirus have immunity.
Yes, at random. It is a stupid placement.
We have no evidence that survivors of coronavirus don't have immunity, and a great deal of evidence to suggest that they do. The question of immunity is linked to health policy, and that workers who have gained immunity can be a strong part of our economic recovery. The silver lining
Also,
to
why
so
am I
many
seeing these trailers when I move
infections in
my
the meat
hands?
processing industry is that a large portion of these workers now have immunity. Those workers should be reassured that they likely won't get it again, instead of being alarmed by media reports that there is no evidence of immunity. You've stated publicly that you'd bet it all that survivors of coronavirus have some form of immunity.
What's the big
Can you
retch?
help
Is
set
it
the
food?
record
Because I'm
straight
super
that the
hungry right
scientific
now.
record, as is being accumulated, is supportive that infection with coronavirus likely leads to some form of immunity. Dr. Fauci.
Yeah,
we don't know.
Thank you for the question,
but
Senator
yes, we
Paul.
hope
Yes,
so.
you're correct that I have said that given what we know about the recovery from viruses such as coronaviruses in general, or even any infectious disease with very few exceptions, that when you have antibody present, it very likely indicates a degree of protection. I think it's in the semantics of how this is expressed when you say, has it been formally proven by long-term natural history studies, which is the only way that you can prove, one, is it protective, which I said and would repeat, is likely that it is, but also what is the degree or titer of antibody that gives you that critical level of protection, and what is the durability? As I've often said, and I again repeat, you can make a reasonable assumption that it would be protective, but natural history studies over a period of months to years will then tell you definitively if that's the case.
And I think that's important because in all likelihood is a good way of putting it. The vast majority of these people will have immunity instead of saying there is no evidence. You know, the WHO kind of fed into this by saying no evidence of immunity. And in reality, there's every evidence stacking up. And in fact, a lot of the different studies
it's
have
called
shown
erring on the
that
side
it's
of caution.
very unlikely that you get it again in the short term. With regard to going back to school,
I mean, responsibility,
one thing that was left out
ethics.
of that discussion is mortality. I mean, shouldn't we at least be discussing what the mortality of children is? This is for Dr. Fauci as well. You know, the mortality between 0 and 18 in the New York data approaches 0. It's not going to be absolutely 0, but it almost approaches 0. Between 18
I thought that every
and
life
45,
was unacceptable.
The mortality in New York was 10
what Trump has
out of
said.
100,000. So really, we do need to be thinking about that. We need to observe with an open mind what went on in Sweden.
But
where the kids
are
kept
they
going to school.
vectors?
The
Are they
mortality
vectors?
per capita in Sweden is actually less than France, less than Italy, less than Spain, less than Belgium, less than the Netherlands, about the same as Switzerland.
Cherry
but
pick,
basically, I don't
cherry
think there's
pick.
anybody arguing that what happened in Sweden is an unacceptable result. I think people are intrigued by it, and we should be. I don't think any of us are certain when we do all these modelings. There have been more people wrong with modeling than right. We're opening up a lot of economies around the U.S., and I hope that people who are predicting doom and gloom and saying, oh, we can't do this, there's going to be a surge, will admit that they were wrong if there isn't a surge. Because I think that's what's
they'll
going
be
to
happy
happen.
to.
In rural states,
I
we
don't
never
think
really
anyone wants
reached
everyone
any
to
sort of
die.
Pandemic levels in Kentucky and other states. We have less deaths in Kentucky than we have in an average flu season. It's not to say this isn't deadly, but really outside of New England, we've had a relatively benign course for this virus nationwide. And I think the one-size-fits-all that we're going to have a national strategy and nobody's going to go to school is kind of ridiculous. We really ought to be doing it school district by school district.
Because New York is not in New England.
And the power needs to be dispersed because
nor is Jersey.
people make
Nor is
predictions.
California.
And really the history of this when we look back will be of wrong prediction after wrong prediction after wrong prediction, starting with Ferguson in England. So I think we ought to have a little bit of humility in our belief that we know what's best for the economy. And as much as I respect you, Dr. Fauci, I don't think you're the end all. I don't think you're the one person that gets to make a decision. We can listen to your advice, but there are people on the other side saying there's not going to be a surge and that we can safely open the economy, and the facts will bear this out. But if we keep kids out of school for another year,
so
what's
let's
gonna
see
happen
who's
is the
right.
Poor and underprivileged kids who don't have a parent that's able to teach them at home are not going to learn for a full year. And I think we ought to look at the Swedish model, and we ought to look at letting our kids get back to school. I think it's a huge mistake if we don't open the schools in the fall. Thank you.
Mr. Chairman, can I respond to that even though there are only 32 seconds left?
Yes, and you might make it clear whether or not you suggested that.
Typically, the witness is allowed as much time as they need. Let's see what happens.
First of all, Senator Paul, thank you for your comments. I have never made myself out to be the end-all and only voice in this. I'm a scientist, a physician, and a public health official. I give advice according to the best scientific evidence. There are a number of other people who come into that and give advice that are more related to the things that you spoke about the need to get the country back open again and economically. I don't give advice about economic things. I don't give advice about anything other than public health. So I wanted to respond to that. The second thing is that you use the word we should be humble about what we don't know. And I think that falls under the fact that we don't know everything about this virus. And we really better be very careful, particularly when it comes to children, because the more and more we learn, we're seeing things about what this virus can do that we didn't see from the studies in China or in Europe. For example, right now, children presenting with COVID-19 who actually have a very strange
16 now?
syndrome, very similar to Kawasaki's syndrome. I think we better be careful if we are not cavalier in thinking that children are completely immune to the deleterious effects.
3 dead in New
you're
York.
Right in the numbers that children in general do much, much better than adults and the elderly, and particularly those with underlying conditions. But I am very careful and hopefully humble in knowing that I don't know everything about this disease, and that's why I'm very reserved in making broad predictions. Thank you.
And also, if I had it, I wouldn't go swimming in the Capitol Hill pool.
Thank you, Mr. Chairman, and
work
Ranking
out
Member
in
Murray
the
and
gym.
our witnesses. I want to try to cover a lot of territory in my 5 minutes, so I'd certainly be appreciative of concise answers.
So don't waste time saying that, just talk.
Redfield. Dr. Redfield, do you think that the current testing protocols at the White House
I am very short
a model
on
for,
time,
other
so
essential workplaces?
I am going to.
I'm sorry, Senator, you broke up at the beginning of your question. If you could just say it again, I'm sorry.
Yes. Dr. Redfield, do you think that the testing protocols currently in place in the White House present a model for other essential workplaces?
Can we get Rand, or can we get
well, I think,
Redfield something other than a 3G phone?
I think one of the important things you bring up is the essential worker guidance that CDC put out. And
At random, I think he's got
it was
CenturyLink.
originally modeled, obviously, on healthcare workers, where there were significant healthcare shortages in individuals that were exposed.
Many workplaces, I'm asking you if you think that the White House protocols for testing are a model for other essential workplaces.
I would just say that I think each workplace has to define their own approach.
No, that is not what the director of the CDC should say.
On the fact that OSHA has not stood up an enforceable, mandatory emergency temporary standard for workers in all sorts of work settings.
Yeah, cheesecloth on Redfield. The
would you
director,
say
there's
that
absolutely
the
no.
PPE rules that
Am I allowed to swear?
in effect right
Fill
now
in your
in
own
the White
swear
House
word here.
are a model
There is
for
absolutely
other
no
essential
beeping way
workplaces?
that the director of the CDC should be telling workplaces that they should set their own standards.
Back to the guidelines that CDC has put out about essential workplaces for people if they are an essential workforce.
That were blocked by the White House 18 days ago? Those guidelines, Mr. Redfield?
Face coverings.
Okay. Admiral Giroir, you have testified about how far you've come with regard to testing assessments. I want to ask you if you believe that we already have a national testing strategy today that spans from the nationwide testing needs assessment to the nationwide testing supply assessment, and a strategy to fill that gap to procure domestically
so the first oral arguments in the first case to try and open up Trump's taxes is, I think, completed. And now they're going to argue the New York
and the PPE needed to conduct
District
those
of New
tests.
York trying to get the taxes.
So thank you for that. We do
in which
have
the
a strategy
government is arguing, or sorry, the Department of Justice, Trump, is arguing that since the president can't be indicted during his term, he can't even be investigated.
Senator Paul
which is two steps beyond lunacy.
Kentucky, Wyoming, or New Jersey, Rhode Island are different, and there are vastly different testing needs. The East Coast will have multiples of testing versus other states, and we're working those individually.
So I know you testified earlier that not only are you working with the states, but you're working with every lab in every state and trying to increase capacity. What about working with those who would be those who would need testing to, say, reopen their school, their university, their business? Each of them have identified what they think are their
Seculo is arguing in the
on,
Trump versus fans course. Do you guys want to go to that or stay
guidance,
here?
Not mandatory enforceable rules, but are you in contact at
and
that
we can have
level?
both screens going at the same time and kind of I think that's what I'm going to do. I'm not even going to wait for you guys.
At that lowest level, or
you know why?
Are you mostly in contact with the states and with the labs?
So over the last few months, we've done a lot of individual work at nursing homes, at meatpacking plants, at really down to the very granular level.
Okay.
Where we are right now, however, is we are really working with the state leadership, with the public health lab, the state epidemiologist,
issuing coercive criminal process against the president. This he cannot do. Thank you, Mr. Chief Justice.
Okay, well, we're too late.
All that, you don't argue that the grand jury cannot investigate the president, do you?
We did not seek to have an injunction, as was the case involving Vice President Agnew, in enjoining the grand jury. We have targeted the utilization of the temporary immunity here to the subpoena. That's correct.
Well, in other words, it's okay for the grand jury to investigate, except it can't use the traditional and most effective device that grand juries have typically used, which is the subpoena.
It can't use a subpoena targeting the president. And under his Article 2 responsibilities and the Supremacy Clause, that is our view would be inappropriate and unconstitutional. So we have not challenged the investigation.
I don't understand.
I don't understand that either.
Theory, in terms of distraction and all that, would seem to go much farther than resisting the subpoena. I don't know why you don't resist the investigation in its entirety, or why your theory wouldn't lead to that.
Well, our position is that criminal process against the president, and that's what we're talking about. That's what's before the court. Criminal process targeting the president is a violation of the Constitution. We did not seek to enforce an injunction or seek an injunction against the grand jury investigating the situation with the president.
Ask him the Fifth Avenue question.
You focus on the distraction to the president, but I don't know why in Clinton versus Jones, we were not persuaded that the distraction in that case meant that discovery could not proceed. And there are different things that distract different people, but I would have thought the discovery in a case like Clinton versus Jones, even though civil, would be distracting.
I really hope that he argues the president is so easily distractible that it's impossible.
Jones, of course, was in federal court. This is in state court. Clinton versus Jones was a civil case. This is a criminal case. And as this court noted on page 691 of its opinion, if, in fact, the Clinton versus Jones case had originated in a state court proceeding, it would raise different issues than separation of powers, concerns over local prejudice. And in footnote 13, this court said that any direct control by a state court over the president may implicate concerns that are different than the interbranch disputes under separation of powers. So it would be
It's a valid argument, but
yes, counsel,
then you still have to fall back on, is the president immune from prosecution?
I'm interested in whether or not you can point us to some express language either at the founding or during the ratification process that provides for this immunity.
Well, there's a couple. There was a colloquy between ultimately Vice President Adams and Senator Ellsworth, where they talked about process against the president, and they took the position that any process against the president would be constitutionally problematic. Thomas Jefferson, of course, wrote in the letter.
I was just going to say that, Chris. Look at that concern on this woman's face. I don't know who she is,
local magistrate,
but she looks concerned and possibly disturbed.
President from north to south and east to west would interfere with the president's responsibilities. And as this court just in the previous argument just stated, the burdensome nature of this is categorical. It's not, you can't just look at the one subpoena. It is the potential for 2,300 DAs, or just 1% of them, 23 DAs issuing process against the president. But the concern over interference from our founding with the president's responsibilities was discussed, and that's why in the Constitution there's process to deal with it.
Does it make a difference when a subpoena goes to a third party?
Certainly not here. Number one, the respondents have either forfeited or waived it. They have conceded in their brief that they are seeking the president's documents. These are the president's documents. He is the real party in interest, and he has the burden, including review with his counsel over any existing privileges.
Not if the defendant has the documents already. There's no burden.
Thank you, Justice Thomas.
Justice Ginsburg?
Come on, follow up, Clarence.
We have said in the grand jury context that the public has a right to every man's evidence. Is it your position that that is save for the president, every man's evidence, save for persons protected by privilege? And there is no privilege involved here. These are non-privileged, non-confidential papers. So is the grand jury right to every man's evidence exclusive of the president, every man except the president? That's one question. And then I wanted you to answer specifically. Paula Jones has held that the president was not immune from civil suits for conduct occurring before he took office. If Paula Jones had sued in state court rather than federal court? Would Clinton have had absolute immunity?
Well, to the second question first, if I might, Justice Ginsburg, this court in Clinton against Jones said that if the case was brought in state court, it would raise different issues of concerns over local prejudice. It was different than the separation of powers issues at play. It was issues involving the Article 2 and the Supremacy Clause. So the court said that on pages 691 and footnote 13. With regard to everyone...
Just that it wasn't decided because of that.
This court has long recognized that the president is not to be treated as an ordinary citizen. He has responsibilities. He is himself a branch of government. He is the only individual that is a branch of government in our federal system. So our position is that the Constitution itself, both in structure and text, supports the position that the president would be temporarily immune from this activity from a state proceeding while he is the president of the United States.
Justice Breyer?
Every man's evidence excludes the president.
If I may, Mr. Chief Justice, Justice Ginsburg, it's not that it excludes the president. The president is not to be treated as an ordinary citizen, and this is a temporary immunity. This is for while the president's in office, and we think that is required by the Constitution. Thank you.
Justice Breyer.
Well, you make a point of the 2,300 district attorneys, but of course in Clinton v. Jones there might be 1 million, I don't know, tens of thousands of people who might bring lawsuits. Perhaps all of them were unfounded, but they could file the paper. Why isn't it sufficient just to apply ordinary standards? I gather ordinarily any person gets a subpoena can come in and say it's unduly burdensome. And what counts as unduly burdensome for a doctor who's in the middle of an operation might be very different from a person who's a salesman. And similarly for the president, all the factors you raise could come in under the title unduly burdensome. So why not just go back? Let the president say, I'll show you precisely how this is burdensome. I'm going to spend time, effort, working all these things out, figuring out what they mean, etc. And if he shows undue burden and lack of connection, he wins. And
they're not going to throw this back, I hope.
That's true of every person. That's Clinton v. Jones. Why not the same here?
Justice Breyer, the hypothetical you just gave, I think, proves the point. By the time you were to prepare, review, analyze the various requests, just in these 3 cases that we have today, shows the burdensome nature. And then to require the President of the United States, and as you raised in your opinion, in a concurring opinion in Clinton versus Jones, that burden is being met just by us being here. But to require the president to have to respond to each and every state district attorney that would like to...
he would hire you, and he'd hire a lawyer to list what the burdens are.
That's it. Breyer's on the side of the Congress, or in this case, the state of New York.
Say what the burdens are.
That's a good sign.
Right, you win that case. They are saying the other side, there are no burdens here.
Well,
you say there are. So send it back and let them figure out what they are.
I think doing that establishes the problem with an analysis of a case-by-case analysis. For instance, in this very case, in this subpoena found on page 118A and 19 of the petition appendix, there's a list of documents that are extensive. You would have to meet with the President of the United States. I mean, could you imagine just for a moment, Justice Breyer, that and you said let's assume the president were to hire me, that I'm going to call the President of the United States today and say, I know you're handling a pandemic right now for the United States, but I need to spend a couple of 2 to 3 hours with you going over a subpoena of documents that are wanted by the New York County District Attorney. I know you're busy, but can you carve me out 2 hours?
Justice Alito?
Are there at least some circumstances in which the U.S. Constitution would permit a local prosecutor to subpoena records?
Yep, the president's just too busy right now to talk to his lawyer for a few minutes. Just too damn busy. Poor guy.
Records contain information.
Look at all that work he's performing.
Source about whether a third party committed a crime, and suppose
this is all this morning.
The end of the president's term would make prosecution
too damn busy.
Or at least very difficult.
No time.
Say that at least in that
still going.
It would be permissible for
all this presidenting
subpoena to be enforced.
In a state court proceeding, the issues of time and burden are still there. Now, in U.S. v. Nixon, that was a case where the president was a witness, and the documents were asked for, and this court said it should be handed over. But in that case, it was very clear that the president was a witness, and the attorney, the independent counsel there, Leon Jaworski, specifically stated to this court that the president was not a target. So if we had a pure witness standpoint, while it's a different case, the same constitutional principles would be at play, but here we're talking about criminal process targeting a president.
Well, was the answer that that would be permissible if the prosecutor were willing to say that the president was not a target, whatever that means?
Well, it wouldn't mean that it's constitutionally permissible. It would raise different issues for the president to consider. But constitutionally, I think that I have to be very clear here. That constitutionally, under Article 2 and the Supremacy Clause, as to a state court proceeding here.
No, he just turned around and walked away.
Witness, it
David.
raises serious issues. Obviously, a very different.
It's a good point by David Mickelson. Maybe if Trump's
nonetheless.
lawyer were an Asian woman, he'd respond to her question.
Counsel, Justice Sotomayor.
Counsel, it seems that you're asking for a broadness of immunity that Justice Thomas pointed out is nowhere in the Constitution. And in fact, the Constitution protects against presidential interference with state criminal proceedings.
It does.
It doesn't allow the president to pardon offenders for state prosecutions or state criminal convictions.
God, that's a good point.
And yet, I find it odd that you want us to rule that there's essentially an absolute immunity from investigative powers, the height of a state's police powers, and that we would permit a civil damages case by a private litigant, which we did in Clinton.
I got to go look at the memo.
Prosecutors have ethical obligations with respect to grand jury investigations. They have to keep those investigations secret. They can be prosecuted if they leak that information. Don't we usually presume that state courts and state prosecutors act as they should and in good faith?
Even if you were to assume that...
If you let me finish. And doesn't the president always have the opportunity to show that a particular subpoena, in fact, was issued in bad faith? President was given that opportunity here, and a affidavit, I understand, was filed under seal, setting forth the reasonable grounds for the investigation. I'm not sure why he's entitled to more immunity for private acts than he should be for public acts.
Well, he's the president of the United States. He is a branch of the federal government.
And can do whatever he wants, period.
We only give judicial officers,
the president will not be questioned.
Officers immunity for acts within their official capacity. If they don't, if judges sexually harass someone, we've said that's not within judicial functions, they can be sued. If congressmen do the same thing, they can be sued. So my question still comes. You're asking for a broader immunity than anyone else gets.
Well, we're asking for a temporary...
We have time for a brief answer, counsel?
I will. We're asking for temporary presidential immunity. I would point out that under New York state law, witnesses before a grand jury are not sworn to secrecy. They can state that they testified and what the nature of their testimony was. I'd also like to point out that there are hundreds of members of the United States Congress and 100 members of the United States Senate. There is one president. Thank you.
Justice Kagan?
So, Mr. Secretary, you've said that
so that's the argument
and made the point, which we have
Matt?
made, that presidents can't be treated just like an ordinary citizen. But it's also true, and indeed a fundamental precept of our constitutional order, that a president isn't above the law.
That argument was separate but equal, except bigger equal.
Subpoenaed, he could be examined as a witness, he could be required to produce papers. And so I guess going back to...
Well, we don't know, Chris.
Like,
we're not hearing from the conservative justices here.
Deal with these two things, that the president president is special.
I mean,
the
Alito,
president
but
is like an ordinary citizen in that he's
no one's
subject
really
to
asking
law,
questions that
is
would
to
sort
say
of
the
lean them
president
to
can
the other
make
side.
these
But we were
usual
watching Fauci
objections
because
that a subpoena recipient can make about harassment or about burden, and the court, in reviewing those, of course, should take seriously the president's objections and treat those with a certain kind of sensitivity and respect due to somebody who is a branch of government. Why isn't that the right way to do it?
women do rock
First, and
sometimes.
I think
Some
here
women.
is the perfect example.
Not Kellyanne
The
Conway.
district attorney copied verbatim the House Oversight Committee and Ways and Means Committee subpoena verbatim. So, and we were just discussing in the previous case the nature of that burden. For counsel, the president hiring counsel, for each time he could be subpoenaed as a witness, or in this particular case as a target, would raise a serious impact on the president's Article 2 functions. So we think a categorical
The president
approach,
doesn't have
and
to
it's
hire
very
counsel.
specific
One will
here.
be appointed by
State
him
process
in the
as
court
to
if it's
the
a state
president,
law.
targeting the president's documents in a criminal proceeding should be prohibited.
If it's a criminal case, it doesn't matter.
Justice Gorsuch?
Counsel, I'd like to return to the question of Clinton versus Jones and how you would have us distinguish it. Yes, it took place in federal court, but it was a civil case, and as has been pointed out, there could have been multiple versions of that in multiple different districts across the country. So what's different about that? How do we avoid the conclusion there that the president wasn't?
That's a great point.
Some special immunity, but here is.
I think the nature of the case that we're dealing with here is not in a vacuum itself. There are other cases that the president is dealing with at the same time. So what may have been a situation for President Clinton with a lawsuit, we have multiple litigation going on, including with the New York Attorney General. So I think the Supremacy Clause issue and the Article 2 issue here is pronounced, as this court alluded to, in Clinton against Jones, for that very reason, this idea that local prejudice would impact the president. So the idea that we would wait until there's more of these, we're already here on 4 subpoenas, or 3 subpoenas, 3 cases involving multiple subpoenas, much of which covers the same documentation. So I think it in fact, Justice Gorsuch, proves the point. We're here because the House has asked for documents that now the district attorney is asking for. So we are seeing that in real time, the burdensome nature of what's happening here.
How is it?
You
how
know,
is this
your
more
job.
burdensome, though, than what took place in
Thank you,
versus
Justice.
Jones? I guess I'm not sure I understand.
Well, I mean, there's a big distinction between a defendant in a civil case and a principal in a criminal case here by the state district of the local
Let me
DA.
stop you there. Yes, they sought the deposition of the president while he was serving. Here, they are seeking records from third parties.
Which the president does not have to be involved in.
Justice Gorsuch. The third party is simply the agent custodian of the president's tax returns on the president's statement of financial conditions. So these are the president's documents that they're asking. And what's to stop them from seeking a deposition of the president? Or, for that matter,
nothing,
asking
because
the president to appear before
Clinton
the
had to testify.
Because if the official
This is not
unofficial
going
is
well
the
for
deciding
Secular.
factor. And our view is that the initiation of process here interferes with the president's official duty. But if there was going to be this unofficial official distinction put in place, well, then what stops the local district attorney from having the president testify, having the president tried?
Justice Kavanaugh?
Would that put an undue burden on the president?
Good afternoon, Mr. Sekulow.
We have that answer.
Just following up on Justice Gorsuch, just explain, if you can, the rationale for having one rule for criminal and another rule for civil. Just assume there's one criminal investigation, that's it. And just explain the rationale for a different rule there.
Well, it's not that it's a different rule, because in this case, because it's within the context of a state proceeding, you have Article 2 concerns, and it's the Supremacy Clause issues, as this court alluded to in Clinton against Jones. That
if you guys are more interested in the other hearings, I can turn the volume up on that one. But it's going to be a bunch of senators asking ridiculous questions. This is more interesting to me, because Sekulow, you know, all those years starring as a lawyer on The Simpsons, he knows his stuff.
The idea that you are the subject or a target of a criminal
Bill
case
Hader
being
is
brought against you is very different than a civil suit where at the end of the day it results
God,
in
Barry
monetary
aged him,
damages, not a loss of liberty. So there's a big distinction between a civil case and a criminal case in that regard, and I think that impacts the standard upon
Chris,
which
you're not a
should be looking at the
Patreon. You don't get to say
temporary presidential immunity. We're talking about
I don't know why I'm not swearing today.
Process targeting the president. This subpoena
Maybe my mom's watching from heaven.
That's what we're talking about here. That burden, that is our concern.
I think the other side.
I can't remember his name, so I can't finish the joke.
Is a bit more consistent with Justice Breyer's concurrence in Clinton versus Jones than with the majority opinion in his concurrence.
Well, I'm staying.
Said that judges hearing a private civil damages action against a sitting president may not issue orders that could significantly distract a president from his official duties. And it's pointed out that that language was not in the majority opinion. What do you think about how we should assess that?
Well, I think civil discovery versus criminal processes are two very distinct processes. And in a civil context, in a civil proceeding, we have the federal rules of civil procedure in the federal court that govern how that process goes forward, and federal judges can take into various considerations, especially dealing with the president. This is a state proceeding initiated by the local district attorney against the sitting president of the United States. So our concern here is the nature of the proceeding itself is why we view categorically that a subpoena targeting the president and his records here would be violated.
Sorry to interrupt. How do you deal with statute of limitations issues?
Well, the statute of limitation issues, of course, are decided under New York state law, and under New York state law, there would be procedures that could be utilized if, in fact, the DA were to elect to start a process like that, or if there were to eventually be action. But I need to say something.
Thank you, counsel.
Thank you, Mr. Chief Judge.
God, it's so ridiculous that you get to the highest court in the land and there's time limits on the questions and answers.
At a minimum, a local prosecutor should have to show he really needs the president's personal records to subpoena them for two reasons. First, as the court suggested in Clinton against Jones, state proceedings can pose a greater threat to the presidency. The 2,300 prosecutors across the country
That's not what it said.
necessarily place more emphasis on local interests than national ones. A special needs standard ensures that federal courts balance the prosecutor's local need for information against national interests, including the president's need to do his job. Second, ordinary grand jury rules are not designed to protect Article II interests. That's why in Nixon, the court held a federal prosecutor had to show a demonstrated specific need for the information sought. A local prosecutor should at least be required to meet the same standard. As the court has repeatedly said, in no case of this kind would a court be required to proceed against the president as against an ordinary citizen. And here the district attorney hasn't tried to meet the special needs standard.
It's an investigation.
We just heard Mr. Sekulow argue in favor of an absolute standard. No circumstances, no how. Your position is that, as you say, at a minimum, the special needs test must be met. Of course, Mr. Sekulow is representing Mr. Trump. You're representing the United States. You're arguing for a more flexible standard. So what was wrong with Mr. Trump's position?
Your Honor, I actually think that Mr. Sekulow makes a very strong argument on the immunity issue. We just don't think it's one that the court needs to address, at least until the prosecutor argues and attempts to meet the special needs standard. Here, since the prosecutor hasn't argued and isn't arguing before this court that he meets the special needs standard, there's no reason for the court to address the broader immunity question, and it's the court's ordinary processes to try to avoid those broader and more difficult questions when possible. And here we think that the special needs standard would fully resolve this case at this stage of the proceedings.
Well, in a typical case, with adequate allegations to say that the standard's implicated, you would say that it goes before a court, and the court will examine whether or not the criteria you talk about, which I gather is the test under Nixon, are met. And under Mr. Sekulo's standard, would not immediately go before the court. He was looking for a ruling from us saying that he's absolutely immune, so the court would have no business addressing such a case. That's a very significant difference.
The lawyers are arguing against themselves on the same side. It's a great point.
You would be able to make that argument to an Article II federal court under our argument if the court found that the prosecutor hadn't met the Nixon special needs standard. It wouldn't need to address the broader immunity question. If it did find that the district attorney met the special needs standard, it would have to then address the broader immunity question. And all we are saying is that unless and until the special need issue is addressed at the threshold, there's no need to address the broader immunity question in this case.
Thank you, counsel. Justice Thomas?
Yes, General Francisco, you mentioned the level of threat to the president or burden on the president. How do we determine that when it's too much?
Well, Your Honor, here I think there are a couple of things that you can take into account. First, the fact that we're in state court I think is quite significant. Local prosecutors are necessarily going to put more emphasis on local interests than national ones. It simply reflects the manner in which they rise to office through elections by local, relatively homogenous political communities.
Really, they should go with the argument that I always make. Too many fucking states.
In a similar way. So there you've already got this risk of local prejudice.
I mean, what if North Dakota and South Dakota bring case against the president? That is undue.
To balance
undue, I say,
against the national ones, including the president's need to do his job. And then secondly, it also has to do with the ordinary grand jury rules.
Yeah, Fauci needs money. He can sell some of those books.
Exercising his authority.
I got nothing.
Those rules were not designed to, and they're not sufficient to protect Article 2
just an endless void.
Under ordinary grand jury rules, a district attorney never has to make a particularized showing of need. Instead, the burden is on the witness to show that the subpoena can have no conceivable relevance to any plausible subject of an investigation. Now, that is a perfectly appropriate standard in the ordinary case, but the reason why Nixon applied the special needs standard above and beyond the ordinary rules of criminal procedure was because the court recognized that the president is the sole person in whom all Article 2 powers are vested. And so he is entitled to a measure of protection above and beyond the ordinary rules. And the special needs standard is one of those measures of protection. To point back to Justice Breyer's very persuasive concurrence in Clinton against Jones, I think Justice Breyer correctly predicted that this court would need to develop special protective procedures precisely for the president in the context of litigation like this.
Justice Ginsburg?
You stress that the states are subordinate sovereigns and they are subject to the Supremacy Clause. But you don't give any credit at all to the 10th Amendment.
Yes!
And the reserve power.
I'm down with RGB.
That's one question that...
That's exactly where she should have gone, and she went there.
As far as the impact of the
she gets all the hand sanitizer right now. Send it to her.
Case more dramatic than the Nixon tapes. Devastating impact on the president. He resigned from office, but yet that was okay. So I really don't get it.
Your Honor,
and he resigned from office,
Honor,
and yet
in terms
that
of
was
the
okay.
10th Amendment,
I love her.
All we're saying is that Article 2 vests all executive power in a single president of the United States. He is the sole person in whom all executive power is vested, and so that necessarily implies that there are limits on what others can do to unduly burden him in his ability to do his job. So all that the special needs standard does is ensure that a prosecutor really needs the president's information before he can enforce that subpoena. Since if he can't even show that he really needs the information, he's necessarily imposing an undue burden on the president and creating a serious risk of harassment. And if you multiply that by 2,300 prosecutors across the country, I think that the risk to the presidency is quite obvious. In terms of the Nixon case, we are actually arguing for the same standard that the court applied in the Nixon case, the special needs standard. We're just saying that a local prosecutor in state court should be, at a minimum, be required to meet the same standard that the federal prosecutor in Nixon had to meet and show that he really does need the information that he's seeking. Since, again, if he doesn't, it's unnecessarily burden. Yes, John.
The grand jury is an investigatory body. It doesn't make, at the outset, specific charging decisions while the investigation is underway. It investigates in order to determine should there be specific charging decisions, but you would have them make a charging decision before they investigate, and that seems to be backward.
Your Honor, respectfully, no. I would simply urge that you apply the same standard that Judge Wald applied in the Inree Fields case, which was a grand jury subpoena issued to the White House, where she concluded properly, in our view, that Nixon's special needs standard ought to apply to grand jury subpoenas. It's not, you don't have to make a charging decision, but you do have to show a demonstrated, specific, particularized need for the information pursuant to which you are issuing the grand jury subpoena.
Justice Breyer?
Thank you. General, I think that Nixon tape case has one thing for you, one thing against you. The thing against you, I think it was a case where executive privilege was asserted.
Anyone know that case?
I think might be more relevant is in that case, the court said, well, there has been first a weighing of the burdensome nature, etc., a lot of other things in that, in the lower courts that have decided that it is appropriate to go forward. Now, what I don't see is why you need a special standard more than that here, the ordinary standard. You would need a decision by us that it's reviewable in federal court. I understand that. But I don't see why you have to go beyond that, where the things you're talking about would be taken into account.
Your Honor, you are absolutely correct that at a minimum we would need federal court review. And in that regard, I would note that the district attorney here agrees that there are Article II limits on what he can do, and that those Article II limits are in federal court. But respectfully, I would suggest that Nixon stands for more than simply some kind of weighing of interests. Nixon applied the special needs standard, and it said that the prosecutor did, in fact, have to show a particularized need for the information. That's all that we're suggesting ought to apply.
Yeah, but wasn't that in the context of assertion of executive privilege?
Excuse me, Your Honor?
Wasn't that in the context of an assertion by the president of executive privilege?
Yes, Your Honor, it was, but litigation about private conduct is also burdensome, and as the court recognized in Clinton against Jones, the president might well need more protection in state court than he gets in federal court precisely because of the risk of local prejudice, and that's why the court reserved judgment on that question. So I think when you put those two things together, it does make it entirely appropriate to hold a local prosecutor in state court to the same standard as the federal prosecutor was held to in the Nixon case. And indeed, even if you were to take the district attorney's own case-specific test, I think you would need the special needs standard. After all, we don't typically get discovery into a grand jury proceeding. So the only way to assess at the front end whether the prosecutor is issuing an unduly burdensome subpoena or issuing a subpoena in bad faith is to require some kind of showing of special need. After all, why would a local...
Justice Alito?
And General, could you explain in more specific terms how you think this showing of special need would be carried out in district court? I assume that the prosecutor would have to make some kind of, would have to reveal what was being investigated and why this particular information was needed for or essential for the investigation. Now, would that be done, would that be reviewed by the judge ex parte? Would it be available to whoever the sitting president is to object to that, to review it and object to it?
Your Honor, it's difficult to answer that question in a vacuum because I think it would very much depend on the particular case, but let me make my best stab at it. I think that in order to have judicial review, you would need, the prosecutor would need to make public as much as could responsibly be made public so that the president would have an opportunity and the president's lawyers would have an opportunity to make their case on the particular facts. If there is a certain amount of evidence that really cannot responsibly be made public, then I think it would be appropriate to consider ex parte proceedings or filings under seal. In all events, we think that that's the type of assessment that needs to be made when you're talking about subpoenas, unprecedented subpoenas like this one, that are from state and local prosecutors targeting the President of the United States. The other place I would point you to is, again, Judge Wald's very good opinion for the D.C. Circuit in the In re Field case, where she does walk through in some amount of detail and unpack how the special needs standard applies to grand jury subpoenas.
How essential must the information be in order to meet this special needs standard? Does it have to be absolutely indispensable, not available from any other source by any conceivable means, or simply very useful?
Your Honor, it's probably somewhere in between those two things. I think it's got to be. I think it's got to be critical to the charging decision, so it can't just be marginally useful or merely duplicative or interesting to a tangential side issue. It does have to be critical to the charging decision. If the information is readily available elsewhere, I don't see how a prosecutor could meet the special needs standard. And if the information he currently does have is sufficient for him to make a responsible charging decision, I also don't think how he could meet the special needs standard. So I guess I would put it somewhere.
Justice Sotomayor?
General, there's always danger in taking a doctrine adopted for one set of needs, and that has to do with needs that are balancing what is clearly recognized in law as executive privilege versus the needs for the proceeding at issue, and transplanting it to a situation that's totally different, where we're not talking about a claim of executive privilege, and we're not talking of executive immunity. We're talking about private activities that predated the president's tenure. So why are we using all that transplanted language, and why don't we get to a standard that takes care of what you're worried about, which is harassment and interference, and simply ask whether the investigation is based on credible suspicion of criminal activity, and whether the subpoena is reasonably calculated to advance that investigation. A standard that looks to whether there is a good faith basis for the state prosecutor's actions, and whether the subpoena is reasonable in its scope and burdens. I don't understand why that sort of standard is inadequate, especially for a proceeding that involves secrecy, like a grand jury subpoena.
But then who decides the undue burden?
Your Honor. First, for the reasons that I think Justice Breyer did persuasively explain in Clinton against Jones, even litigation about private conduct can be quite burdensome, and that is particularly so when you're talking about private conduct that's being litigated in state court pursuant to state procedures. So I think that's why he correctly predicted that this court would need in future cases to develop special protective procedures precisely in this context. And secondly, I think that the special protective procedure that we are proposing here is necessary even under Your Honor's general approach. After all, why would a prosecutor take the unprecedented step of issuing a subpoena to the President of the United States for personal records from a local prosecutor if he can't even show that he really needs the information that he's seeking? If he can't make that showing,
because it's a secret grand jury.
Reason to be a little bit suspicious. After all, very prosecutors.
You compromise the investigation.
So, General, a couple of times now in response to Justice Breyer and Justice Sotomayor, you've explained why we should use the standard from executive privilege cases by saying, well, litigation about private conduct is also burdensome. But the point about executive privilege cases is not that it's burdensome. I mean, the critical factor is the weighty interest that a president has in communicating with advisors on official matters, often about national security, often about military matters, and the need for confidentiality in that. And that's why the Nixon standard was developed, not because of generalized ideas about burdensomeness, which can be dealt with in other ways. So again, why should that standard be used here?
Why are we even talking about it?
Respectfully, Your Honor, because I think that they're parallel interests. Executive privilege, you are right, is meant to protect the confidentiality of communications, but Article 2 more generally is meant to protect the president from being unduly burdened in his ability to carry out his responsibilities. And
Show me the burden.
I think that's particularly necessary when you're talking about state court proceedings by the many, many 2,300 local prosecutors across the country who, again, are more responsive to local political constituencies and local interests than national ones. So I think that when you look at Article...
So their argument is 2,300 local jurisdictions might bring criminal grand jury charges against the president.
Addressed in any subpoena, and I'm sure that courts, when it gets to the president and the special responsibilities of the president, will address those interests with respect, with sensitivity, especially if we tell them so. So why would you need this heightened standard that is meant to protect confidential communications about official government business?
For two reasons, Your Honor. First, because under the ordinary grand jury rules, the only question as to burdensomeness is whether the subpoena has any conceivable relevance to any plausible subject of investigation and therefore is unduly burdensome. And secondly, I think that judgment has to be made by federal courts, not state courts, because state courts, like local prosecutors, are going to be more responsive to local interests. After all, in New York State, trial court judges, like the district attorneys, are elected in partisan elections. So all we're saying is that this is the type of assessment that needs to be made in federal court, and the most appropriate and easy to apply standard is the standard that you've already been applying for 50 years under the Nixon case. And we think that that is
Justice Gorsuch?
Federal justices and judges are appointed by partisan presidents.
How this standard that you're proposing would play out in practice.
Therefore, we can't have any courts.
A local prosecutor saying, I'm investigating a tax infraction. And the best and maybe only evidence of
no
that
animals like
infraction
Trump, Bob.
are
But
the
you're
tax
absolutely
records
right.
in the
Point
possession
taken.
of the potential defendant. Why wouldn't that meet the special heightened test that you proposed in every case? And if it does, then what have we achieved?
Well, Your Honor, I think it would depend on who the potential defendant is. If the potential defendant is the President of the United States, here the district attorney doesn't contest the fact that he cannot indict the President of the United States until after he leaves office. So he wouldn't be able to show that he needs the information now in order to indict the President of the United States. Of course, if the potential defendant is somebody else, then it might start looking closer to the Nixon case itself, where the special counsel was investigating a third party. And I think that would, in fact, be a relevant consideration under the special needs standard.
So
special
counsels.
Last portion of it. Let's say the infraction is by a corporation or some entity, and we need the prosecutor's going to say we need these materials in order to determine whether there is an infraction.
Yeah.
Right.
Why wouldn't that qualify under your standard?
I think that would certainly be a relevant thing to take into account under our standard. And if he actually met the special need test with respect to the information and found that it was really necessary in order to bring charges against that third party.
I sometimes turn my mic off, Bauer, so it may not be you, but you should be getting a constant stream of audio from the feed, not me, but the desktop audio that's coming through. Them talking.
Some reasonable suspicion.
Are you losing audio from the people talking?
Some entity. Is that enough?
Your Honor, I think it's... I think it's more than that. I think he's got to show that the information he's seeking is critical to him responsibly making a charging decision, that he can't get that information from somewhere else, and the information that he does have is insufficient. It's essentially the same standard this court applied in Nixon, the D.C. Circuit applied in the Resealed case. You know, it's not like it's a hard and fast, bright line rule, but it is an administrable rule that courts have been applying for some 50 years now.
Thank you, counsel. Justice Kavanaugh.
Thank you, Mr. Chief Justice, and good afternoon, General Francisco.
He still likes beer.
I want to follow up on Justice Thomas and Justice Kagan and really zero in on what the Article 2 interest is before we talk about what standard. And I think in Justice Breyer's concurrence in Clinton against Jones, he referred to the interest in time and energy distraction, which he drew from Nixon versus Fitzgerald, a different Nixon case, as an independent Article 2 interest that is distinct from distortion of official decision-making, which would be more the executive privilege kind of interest. Is that the Article 2 interest you're zeroing in on, or is it something else?
Well, Your Honor, respectfully, I think it's both of them, and as I read Justice Breyer's opinion, he likewise understood it to be both of them. The whole idea is that Article 2 vests all executive power in a single person, and that necessarily means that others can't unnecessarily hobble or debilitate that person in his ability to responsibly carry out his duties. So the whole point of the special needs standard is to ensure that others, including prosecutors, can't unnecessarily impede the president in carrying out his responsibilities.
Well, Justice Breyer is there.
They have to show that they really need the information that they're seeking. Since if you have 2,300 prosecutors that are unnecessarily hitting the president with subpoenas and none of them can actually show they really need that information, you're necessarily going to be undermining the president's ability to effectively carry out the Article 2 duties that the Constitution entrusts to him and to him alone on behalf of the entire country.
Thank you, counsel.
So if we get to a point where 2,300 different jurisdictions are suing the president...
Please the court. There are two principles at issue in this case. One is the central role of the president in the functioning of our national government and the need to avoid interfering with the president's ability to carry out those important duties. The other principle is that under our Constitution, when a president acts as a private individual, he or she has responsibilities like every other citizen, including compliance with legal process. In particular, this court has long held that American presidents are not above having to provide evidence in response to a law enforcement inquiry.
Ted Danson's
We're mindful
right.
that as a state actor, our office cannot investigate a president for any official acts, and that we cannot prosecute a president while in office. But here, we're talking about a subpoena sent to a third party concerning private conduct by a variety of individuals and businesses. Yes, one of them is the president, but no one's been targeted or charged with anything. There's no claim of any official acts or any executive privilege. As the courts below found, the subpoena imposes no Article 2 burden whatsoever and was not born of any political animus or intent to harass. Instead, it was prompted by public reports that certain business transactions in our jurisdiction were possibly illegal. Given those allegations, our office would have been remiss not to follow up. In response, the president asked the court to overturn 200 years of precedent by declaring he has a blanket immunity while in office from any legal inquiry, even for his prior private acts, even though that could result in a permanent immunity for him and the other parties if the statutes of limitation expire.
Again, the president's busy.
The discovery of evidence that could exonerate the individuals involved. Finally, his novel claim also asked the court to presume that state actors have a, quote, reckless mania that will cause them to, quote, relentlessly harass presidents, and that state and federal courts will allow prosecutors to do so. Of course, there's no historical support for this claim, which flies in the face of federalism. The supposed floodgates have been open for generations, and there's never been a flood. The only thing new here is the subpoena comes from the state. But absent a constitutional burden, that shouldn't lead the court to abandon its long-standing respect for state criminal proceedings.
Thank you, counsel. We've had the cases this morning and this case, and they are in many respects very similar. In the case of the subpoena itself, they're identical. But I think in other respects, they're really quite different. The separation of powers case this morning involved entities in an ongoing relationship, the House and the President, and issues of this sort, although always very important, come up with some regularity. There's often disputes between the White House and Congress over documents, and almost always they're worked out because each of those branches have authorities and powers that affect each other. If the Senate asks for documents from the White House and the White House doesn't give them, then the Senate says, well, we're going to, take our time confirming your nominees and back and forth. But with respect to local prosecutors, you don't have that ongoing relationship. So the possibility of working something out is far less evident, and if you're doing that, the stakes are, well, it's just a little more difficult because there isn't that ongoing relationship. So shouldn't there be a higher standard before we permit the district attorneys from around the country, but there are also more of them than the two houses of Congress, 2,300 of them. Shouldn't there be a higher standard than in the case of the separation of powers dispute?
Your Honor, I think our answer to that is yes. And putting aside its relationship or not to the separation of powers analysis, I'd like to address the DOJ's proposed heightened showing standard because...
Wow, you're right, Lori.
Let me put it this way.
I heard Double Rainbow Guy died. What does it mean?
New heightened showing proposal doesn't work. And a number of questions in the last argument, I think, touched on some of these concepts, if I might. First, one problem is that the approach that they're suggesting really reverses the court's prior approach to fact-finding in these types of cases in a way that I think would harm the grand jury process, which I can explain. So, again, we agree there should be a heightened showing requirement, but my point is only after a president has already established an actual Article II burden. Otherwise, there's nothing for a court to weigh in the balancing of Article II interests against the need for legal process, and that balancing and that sequencing, frankly, was both central in both Nixon and Clinton cases. Here,
would you articulate for me precisely what standard you think should apply in your case, and in what sense is it more rigorous than that would apply in the dispute between the White House and Congress?
Yes, I think we believe that a prosecutor, if there's been an affirmative showing by a president of an Article II burden, and of course the courts have below held that there has not been such a showing here, but if in a different case there was such a showing made, we believe a prosecutor should be required to show, one, an objective basis for the investigation, and two, a reasonable probability the request would yield relevant information. We think language like that would be more consistent with past cases of this court and with the realities of a grand jury investigation. And frankly, the courts below also already found that we've met that standard here. The problem is that the alternative of requiring a state prosecutor to get permission first from a federal judge for any request relating to a president's business activities would undermine this court's prior rulings, like the one in our enterprises, that a grand jury shouldn't be burdened by procedural challenges and delays because it's a confidential process and not an adversarial proceeding. And the DOJ's new standard just ignores that. The other problem...
Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Dunn, you were about to say how DOJ's approach would harm the grand jury process. Would you finish that?
Yes, and I think I was just addressing that, Justice Thomas. That is,
because it delays the grand jury.
To require us in any given case to run across the street to federal court and say, by the way, we have an investigation underway. It happens to touch on a president's prior business transactions in which he and others were involved in, and we'd like to get permission to send a subpoena for records that are in either the possession of a president or maybe the president's agents, like his accounting firm here. Again, it completely upends the way that a grand jury process is supposed to work. If I might, the second big problem, I think, with the DOJ's analysis is that the language that they've chosen just
these are
work,
tax returns before he was president, Lori. So theoretically, this could happen to any president.
It calls for a, quote, stringent showing that the request is,
but
quote,
you're making the argument against undue burden, or for undue burden, or proving undue burden, because there's,
in the context of a grand jury,
since these taxes happened before, or lack of taxes happened before Trump was president, there's nothing about those taxes now which are already in the possession of the third party that's going to cause him an undue burden. He doesn't really have to do anything,
because
which is what we found out is true of the presidency.
And B, we have already met the standard by the district court's finding that our investigation is well-founded and brought in good faith. So
what limits a grand jury process in New York? What are the limits?
Well, the limits are, I think, the same basically as they are in a federal court in most other states, Your Honor. I mean, yes, the recipient of a subpoena who has a basis to argue either a privilege or a burden of some sort has the right, as the president did here, to go into court and make those factual arguments that it's that either it should be quashed or constrained in some fashion. There's a grand jury judge who supervises all grand juries and their activities, who's always available here. But I think the more important point, perhaps, Your Honor, is that obviously, given the decision of the Court of Appeals below in this case, and to address that concern and that footnote in Clinton, at this point, it's clear that a president in particular who has a concern about this kind of impact on Article 2 duties now always has the ability to go into federal court and not into state court, which was the main concern in that footnote in Clinton.
What if you thought the president said it was impossible for him to do his job as opposed to just being burdened? Would we have a role to limit or somehow end the grand jury process?
Impossible to do his job is a burden.
Your Honor. I mean, I think that's the point of the case-specific analysis is that it gives a court, and here a federal court, to hear a concern like that expressed. And if the concern is, somehow this shuts my office down, or it is
yes,
a real burden, it's not just a speculative mental distraction claim.
Which is odd, because usually they come like at 6:30 in the morning.
To impose a wide variety of limitations, including, if necessary, to shut an investigation down or to shut.
I know, Lori. It's weird. Thomas has been asking a lot of questions, which
this court's prior
I'm not sure what that means.
Nixon and Clinton and others, which have decided,
but they've been
to apply
questions that
the case-specific analysis.
They don't make Trump look good, which tells us that Trump's going to win because it's 2020.
With a categorical prophylactic rule, I just think that that's not appropriate here when it's also case-specific.
Thank you.
Justice Ginsburg?
The principal objections that have been raised is that when you're dealing with federal prosecutions, it's all controlled by the Attorney General. But here you have 2,300 district attorneys, each armed with grand jury subpoena power. So the control that exists in federal courts with the Attorney General at the helm and no one controlling all of these state district attorneys.
I understand, Your Honor, and I think really what that gets centrally to is the consistent argument here about the parade of horribles, if you will. And if I could address that, I think there's several answers to that concern. First of all, there's really no empirical basis in history for this apocalyptic prediction. The same claim was made and rejected by this court in Nixon and then in Clinton. That, of course, was decades ago, and there's not been a flood of subpoenas or litigations or prosecutions of presidents by states or federal prosecutors. Second, as a practical matter, this notion that there are 2,300 prosecutors out there writing with their subpoena pads open, there's just no basis to think that an army of local prosecutors like that would even have jurisdiction over a president, especially for private conduct in the first place. Here, New York City, of course, has a particular connection to the Trump organization and its financial transactions because it's headquartered here. It's not likely that more than one or many states, much less 2,300 counties, will ever have that kind of connection to a president's private conduct. Third, I think as Justice Ginsburg, you mentioned in the last argument, this view that there's a reckless mania by local prosecutors contradicts this court's longstanding presumption in favor of regularity and deference to state proceedings. And so to finish off, the limitation I think that you're asking about really comes in the form of the case-specific showing that past cases from this court have established. Because if there is a concern about the behavior of a local prosecutor, any president, when necessary, but it's been few and far between over the decades, can run now not just into state court, which Clinton thought could be problematic, but can run into federal court and raise exactly the kind of claim that the president has raised here. That's the limitation.
Thank you.
Justice Breyer.
Well, thank you. I agree with you that the two basic principles you set at the outcome are there: every man's evidence versus the constitutional statement that the president is the executive, Article 2, and they conflict. Just as in the first case, the power of Congress, Article 1 and Article 2 conflict. All right.
I think that I would say they don't conflict, but yes, they're in tension.
They're in tension. Fine. All right. Now, a possible solution is, say, no absolute rule, but just send it to the ordinary system for weighing the needs versus the burdens, and the different sides have to say what they are, and then have that reviewable in federal court. And because of the nature of it, and we could list in an opinion the kinds of things that might not be or might be relevant.
Oh, thank you. Sorry, Chris, I keep turning off my mic. Yeah, Lizzie, have a great day. Thank you. You're awesome.
All right, now all that would take time.
Be safe.
But time itself would discourage prosecutors from doing this,
mail,
which might be good.
Or mails.
And time itself would encourage.
You know what? You do what you want to do.
Congress.
You're probably gone by now. Sorry, I already said goodbye to you, but
all right, I don't
my mic was
that
off.
As being wedded to it. I want to know your reaction.
Oh, you're still here. Okay, well, goodbye.
What you're describing is exactly what this court held in
Have
Clinton,
a good day.
And it's exactly, frankly, what has happened now in this case, which is, yes, in this case, the president decided to pursue his claim of immunity in federal court versus state court, which is fine and now available, I think, in the future to all presidents. But I think the fact that that is what should happen in the ordinary course and which can happen in the ordinary course is, again, the solution and the limiting principle here, because it does make it clear that there is a remedy and discourages, I would have thought, bad faith impulses by any state or local prosecutor who might harbor such an impulse, and provides an outlet that makes sure that it can't get out of control. But again, that's the beauty of the case-specific analysis. I don't think these things lend themselves to categorical prophylactic rules, and that's been the approach from this court.
Prophylactic.
Thank you.
Justice Alito?
Immaturity right there.
As I understand your proposed standard, there would be available review in federal court, and the prosecutor would have to show an objective basis for the subpoena and the relevance of the subpoena to the investigation. Is that correct?
Basically, on our language like that, I said point 2 was a reasonable probability that will yield relevant information, but yes, that's the concept.
Okay, reasonable probability. What would be your objection to a somewhat more demanding standard? So the prosecutor would have to show that the information can't be obtained from another source, or it would be very difficult to obtain it from another source, and the information unless the information is obtained right now, as opposed to at the end of the president's term, there would be some serious prejudice to the investigation.
Your Honor, I frankly don't think that any of those concepts are foreign to the standard that I articulated, and I think they are relevant, in fact, to the objective basis and relevance points. Here, for example, and again, I think that the court below, the district court in particular, heard our explanations, and including the fact that the reason why we went to Mazars is not to do an end run around negotiations with the president's lawyers. It's because Mazars, as the outside accounting firm, is, as far as we could tell, the only repository of what might be the most important documents in an investigation like this, which are not just the tax returns, but the surrounding accounting materials and work papers, et cetera, which shed light on the good faith or not of the transaction. So my short answer, I'm sorry, is that I think those those concepts would be fine and not unduly burdensome in the context of the standard that I set forth.
Can I ask you one other thing? Do you think that the adjudication of this in all cases of a similar nature would depend in any way on state law and practice regarding grand jury secrecy? In federal court, the rules of grand jury secrecy are, of course, very strict. States have, suppose a particular state
too many states,
no restriction on the revelation by a member of the grand jury or perhaps even by the prosecutor of the information that is supplied in compliance with a subpoena.
Well, Your Honor, I'm not aware of any other states having that kind of lax or non-existent grand jury secrecy rule. I can assure the court that in New York State, our grand jury secrecy laws are at least as strict as under the federal system. But putting that aside, if in fact the fact pattern presents to a judge the prospect that the information in fact will become public, and a president were to persuade a judge that that publication of the documents at issue would themselves impose some sort of Article II burden or other interference with his executive duties in that given state, I suppose that would be part of the case-specific analysis that the court could.
We don't need one Dakota
And take into account in deciding whether
except Dakota Fanning
there should be some limitation.
Is she still around?
Or even a quashing of the subpoena itself. I think that's part of the case-specific analysis.
I mean, we both know that prosecutors have different, that there are prosecutors who leak all sorts of information, including grand jury information, to all sorts of media sources, including specifically the New York Times. If there were a showing that was a risk, would that have a bearing on this?
Your Honor, it's hard for me to.
God, I hope it's a risk.
I'm not aware of any kind of real pattern or practice of leaking of actual grand jury materials that are covered by grand jury secrecy. Yes, in all different kinds of offices, there are at times, leaks of status of cases and that kind of thing. But I am not aware, and our grand jury secrecy rules really prevent prosecutors, I believe, from actually turning over confidential grand jury secrecy materials to.
You're not aware of this ever happening? Your office is never requested by media in the New York City area to disclose confidential investigative information?
No.
But do they?
They ask all the time, Your Honor, and the answer is consistently no, at least as far as I can represent. But what I'm trying to draw a distinction between is people commenting to reporters all the time, off the record, that kind of thing, versus turning over actual materials like, the voluminous tax returns or other sensitive documents that have been gathered and which are covered by grand jury secrecy. That's what I just don't see happening here, and I think history supports that view.
When you refer to an Article II burden, does that include the burden of harassment, the burden of using subpoenas for political purposes?
Yes, Your Honor, I would certainly include that there. And again, there's been an express finding below here that there is
this guy here looks presidential.
Was well founded, that there was no harassment or bad faith in our bringing of the subpoena.
Thank you. Justice Sotomayor?
Counsel, did I understand your answer to Justice Alito to be that you are in agreement with the SG that we should impose a heightened need standard, a special needs standard?
No, Your Honor, I think we're all now calling it the heightened showing standard, or in the DOJ's lexicon now, the heightened need standard. But I think what I'm articulating is a very different standard in terms of the actual language to be looked at and imposed. Again, I think.
But wait, if you can, counsel, because I want to be very precise. If your standard includes what the heightened need standard has, then why not call it what it is, heightened need? There has to be a reason you think we shouldn't call it that, and I don't know that I understand what difference you're proposing.
I'm sorry, Justice Sotomayor. The concern I have with the DOJ language is, again, calling for a stringent showing that a subpoena request is directly relevant to central issues at trial and other concepts like that. What I'm trying to propose is something I think which is not so strict and which is not limited to charging and trial-related concepts, but which would be workable in the context of a grand jury subpoena. And again, whatever the standard is that we're articulating, I want to stress that I believe that our office has met that standard here, even under the DOJ's proposal, because of the findings by the district court.
Right. Tell me why the heightened standard would interfere with the grand jury process.
Well, I think, Your Honor, among other things, the DOJ's proposed application of its standard, if you read its brief, would confer the same absolute immunity the president is seeking here. What they say is, since you can't indict while in office, you don't need the documents while he's in office. And frankly, that's an outcome that would apply in a case. No subpoena could pass that test because they basically say, you have to wait until he's out of office before gathering information because you don't need it in the meantime. And so their definition of heightened need says you don't need it while he's in office. Well, that's not workable here.
Why not?
Because, well, obviously, Your Honor, if we were to wait until a president...
The witnesses have to testify as soon as possible.
Like this, first, it would risk the loss of evidence, the fading of memories, and unavailability of witnesses, which is exactly where the DOJ Moss
Okay, she's got to be arguing against herself here.
That a president,
you ask the question so that he can clarify and say, well, you have to gather the evidence while the evidence is hot, just the same as Mueller documented everything so that Trump can be charged later. You put everything down on record because memories fade, exactly as he said.
And waiting like that.
Is anyone even listening anymore? This is really getting into the weeds.
Above the law, if the limitations period expires. So delay here.
I'm going to get some coffee.
As absolute immunity and absolute permanent immunity for the president and others if a statute of limitations expires. That's the problem with the delay.
Well, the other side says the statute would be told against the president, but you're right, it wouldn't be told against other people who may or may not have been committed crimes that he may or may not be a part of, correct?
Correct, and that's important, Your Honor, for the third parties. But just to address my friend on the other side's comment about the tolling, I'm not aware in state law of any doctrine of implied tolling that would apply here to protect the state's interests in investigating and potentially prosecuting, if necessary, down the road. I don't know where that concept comes from, but it's never been articulated by this court. There's no act of Congress which permits that kind of tolling here. And so for us, the statute of limitations is a big concern. We've already lost 9 months of time in this investigation due to this lawsuit. And again, every minute that goes by is, basically without even a decision on the merits here, granting the same kind of temporary absolute immunity that the president is seeking here.
Justice Kagan?
Mr. Dunn, you've been talking about how to analyze these burdens in a case-specific way, the burdens both in terms of the president's time and in terms of any possibility of harassment of the use of a subpoena for political purposes. And Mr. Sekulow said that the burdensome nature of these subpoenas is categorical. That was his term. And I take him to mean that that any subpoena interferes with the president's responsibilities or undermines the president in his handling of the office. So what's the answer to that?
Your Honor, I would make 3 points. I think the fact is that the court addressed this question, I think, in Clinton and concluded that a president can't realistically be shielded from every sort of private distraction, including some forms of legal process, especially in our modern age. So that's why it's up to a court to evaluate and protect a president, depending on the circumstances, on a case-by-case basis. Secondly, here, the claim of, the possible mental distraction is completely speculative, really. It's based on the notion that the president might be, worried and distracted about where an investigation might lead someday. It's not based on any actual Article II burden or interference of the sort the court was asking President Clinton to demonstrate in Clinton v. Jones. And third, I'd say if that's really the concern, I think it's wrong to think that even a categorical rule here would provide comfort to a distractible president like that. So, for example, nobody suggests here that we should be barred from continuing to investigate the president's prior colleagues. So if we now gather documents from them that reflect past communications with him while he was CEO, are we then supposed to be stopped because it could create a fear in him that the investigation of others might lead him to be accused of something someday? Again, my point is that this speculative mental distress standard is not an appropriate basis to draw a constitutional bright line. That's why the case-specific approach is more appropriate.
And speculative mental distress, how about if they really mean political undermining?
Well, I mean, that's beyond the ken of our office, Your Honor. And as, again, the district court found, there was no bad faith intended by virtue of our subpoena. So I don't know. It's already been determined here there's no intent to politically undermine. So I don't know how a court could try to evaluate that, and I'm not sure that would be appropriate.
Mr. Sekulow suggests that you've shown your bad faith by taking the language of the House Oversight Committee's subpoena.
Yes, Your Honor, and I think we've tried to address that. I mean, the simple fact is that in 2018, when our investigation started and thereafter, as we've spelled out, and there were a series of public disclosures in the press about possibly illegal transactions involving tax and other financial improprieties. And at the time of the House subpoenas and then our subpoena, it was clear that both our office and the House committees were looking at the same public allegations in that regard. In a situation like that, once the House subpoena became public, it's not unusual for an office like ours to model our subpoena language on that which has already been made public from a different source when it's going to the same recipient. It makes it easier on the recipient in the process. There was absolutely no communication between our office and the House about this. There's nothing sinister about it, Your Honor.
Thank you.
Justice Gorsuch?
Counsel, I'd like to return to your colloquy with Justices Alito and Sotomayor, because I guess I'm uncertain what the daylight is between the test you're proposing and the test the Solicitor General has suggested. It seems like both of you agree that these questions should be resolved in federal court, and you've suggested that the prosecutor should have to demonstrate an objective basis for the investigation, and that there's at least a reasonable probability that the information sought will be helpful to that investigation, that it can't be obtained elsewhere, and that it's needed now rather than at the end of the president's term because of some serious prejudice that might take place in between. As I understood your discussion with Justice Sotomayor, you suggested that the difference is the Solicitor General thinks there should be an absolute immunity till the end of the term. I confess I didn't read the brief that way. I read it as suggesting the district attorney has to show why there's a need for the president's records now rather than at the end of the term. And I understood your discussion with Justice Alito to agree that that would be a relevant consideration. What am I missing?
I think, Your Honor, putting aside the language differences, which I tried to highlight, I think the most important distinction is what I tried to note at the outset, which is the sequencing of the showings that need to be made. Because what the DOJ is proposing, as I understand it, is that in the first instance, it has to be the prosecutor who goes to court, goes to federal court in this instance now, and makes an affirmative showing that the standard has been met, that there's some objective basis, and it can't be obtained elsewhere, et cetera, and only after such a showing has been made by the prosecutor, according to the DOJ, does the burden then shift to the president to show Article 2 burden. And I think that's what's completely backwards and inconsistent with Nixon and Clinton. I think it's much more appropriate for the president, as the moving party, as here, to be required to make a showing, as any other litigant would be the case. Again, here we're talking about purely private conduct, to explain why this request somehow impacts not just on a need to gather documents, which is not the case here, but on an actual Article 2 burden. And only once that showing has been made should, I think, the burden shift to the prosecution, consistent with past cases by this court, to explain why, nonetheless, it's still necessary to permit the court at that point to conduct the balancing of apples and apples in terms of coming to the right conclusion in a specific case. To me,
so Mr. Dunn, am I correct in thinking then that you agree that the forum should be federal court? You agree on all the relevant considerations the necessity of the information, that it can't be obtained elsewhere, the timing issues, all are relevant considerations. It's just who bears the burden?
Yes,
Is that
Your
what
Honor.
we're fighting over?
Well, I'm maybe with the DOJ, there's less daylight between than us and the president's lawyers. But I think the important point that I would want to leave the court with is that even if one were to adopt that standard, or even frankly, I think the DOJ standard, the fact is we've already met that test given the findings of the courts below.
Oh, I know you think you win no matter what. We have to write a rule that's presumptively of some value going, and isn't just about one president, but it's about the presidency. And I'm just trying to understand what daylight actually exists. And is it fair to say that the only daylight that exists between you and the Solicitor General is who bears the burden of proof? I'm not trying to put words in your mouth. I'm trying to understand.
No, Your Honor, I think it is the burden and the difference in language, which I pointed out to Justice Sotomayor. I think that those differences are important because I don't think that the DOJ's language works in a grand jury investigation.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice, and good afternoon,
After
Mr.
Kavanaugh's
John.
question, we might switch back to the hearings.
With Justice Gorsuch, the difference between
Congressional
the Nixon
hearings.
heightened need standard, you said it doesn't work in a grand jury. What do you do with Judge Wald's opinion in Ray's sealed case, which took Nixon and did apply it in a grand jury context?
Yes, well, Justice Kavanaugh, as I think you mentioned in the earlier argument, the fact remains that the In Re sealed case was indeed applying the Nixon standard as the Nixon court contemplated to a claim of executive privilege. And as has been pointed out earlier today, I think that's a very different analysis to be undertaken for a very different purpose. And I don't think one can just simply import that language and apply it to
I'm sorry to interrupt. Let's leave that for a moment. But the point on the grand jury versus trial, just on that point, Judge Wald's opinion did take Nixon and apply it in the grand jury context.
Why is there no closed caption for the
Supreme
Supreme
Court? In the grand
Court?
jury context, when we're talking about a privilege analysis, I think that language is appropriate. Because at that point, you already have, once there's been an affirmative showing that established that there is a privilege to be addressed, then of course, like with any attorney-client privilege, for example, it's necessary for the court then to turn to the demand or the request and the documents that are at issue and evaluate them in light of this.
If we can, move on to the Article 2 issue then. Do you acknowledge that there's an Article 2 interest at stake here?
Yes.
And what do you think it is?
I think it's the Article 2 interest to be free from unreasonable burdens on the duties and obligations of the presidency, and that's the same analysis that was applied in Nixon and in Clinton.
And do you think time, what Justice Breyer referred to as time and energy distraction, are appropriate Article 2 interests?
Well, yes, as a matter of degree. Again, that was the court's analysis in Clinton. Recall there that although this court allowed the litigation to proceed, of course, appropriately, as I think is the case here, there's a need to make sure that the courts that are overseeing this kind of objection are undertaking an analysis of what the burdens are.
Clinton had to testify over closed circuit television, had to answer questions before a grand jury, whereas this is just some old tax returns from Trump. If the standard of undue burden is not met by Clinton testifying live, then how can some paperwork even come close?
One is the federal state, the other is the civil criminal. On the civil criminal, I suppose one thing I'd like to hear you address is, in a civil case, and the court emphasized this in Clinton versus Jones, there's an individual person at stake who has a claim. There's not the same in a criminal context. Obviously, there are different and very important interests there, but not the individual interests. Can you address that?
Well, that's one distinction, Your Honor. I suppose on the other side of the coin, there is the important difference that there are potentially thousands or many more potential private litigants out there who are not bound by the kinds of ethical and jurisdictional and other constraints that prosecutors are bound by, and to which this court has long paid deference. I think that the reason for concern in a civil context is actually much higher than it should be.
sorry if I can get my last question in on the federal state. If there is an Article 2 interest at stake, and you said that there is, it's different, of course, from the executive privilege interest, but there's some Article 2 interest at stake. I think the other side says it would be odd if the standard were easier to meet for a state prosecutor than for a federal prosecutor, and I just want to give you an opportunity to address that.
Yeah, frankly, I don't really understand that distinction. I think under the analysis that this court has applied before and the one we're talking about now, the same analysis would apply in terms of a case-specific evaluation in the context of the particular facts of a particular request.
So just to stop you there, you're okay with whatever standard applies to a federal prosecutor in a case where there's an Article 2 interest also applying to the state prosecutor?
Well, I'm not sure exactly what you have in mind, Your Honor, but I
don't know where Kavanaugh's going with this.
You're not okay with the Nixon standard, I don't think, but I just want to explore that.
No, because of the fact that that was applying to claims of executive privilege. But I think to get to your point, I think what it comes down
Kerry's
to is
good,
that,
by the way.
in the Nixon and Clinton cases, we're talking about Article 3 versus we're talking about separation of powers analysis. Here, the analogy is we're balancing federalism and 10th Amendment concerns about police power of the states against the Supremacy Clause. So it's a different analysis, perhaps, but it's very analogous.
Is Lamar Alexander? Does he live on the set of 60 Minutes?
We have time for a little
he's
bit
gone
of a
now.
second round. And I guess the thing that I would like to focus on first is this question of how you examine the burden on the
We now go live to Lamar Alexander's house.
I just don't understand how.
We'll yield time to the gentlelady from.
President being asked
I don't know his voice well enough.
Time to reviewing, for example, in this case, the 10 years of document.
Okay, we're gonna go back to the hearings because this is just getting into the weeds here.
Says, here's what I'm doing. I've got this pandemic.
If we know it's safe to travel and visit our work at our hotel.
Although I've got to believe it that by this point they've been doing this for a couple of hours now. This is just going to be the same. Hey, it's really dangerous. No, we need the economy. Hey, it's really dangerous. No, we need the economy.
Understanding that this takes time to develop and
if anyone's been watching
both
this
safety and efficacy.
If anything's happened,
I'd like
I've
to
been
hear
kind
more
of paying
about what
attention
research is happening
and looking at the
regarding
chyrons.
Preventative medication research that could be helpful
Have we learned
in
anything?
the time frame before a vaccine, and especially before one is widely available. So I'd like to ask if this could be part of the path to helping us begin to reopen our economy safely and bring visitors not only back to Nevada, but across our country. So Dr. Fauci, what research is currently happening to identify potential monoclonal antibody preventative treatments or other therapeutics? If the right antibody is identified or can be identified, could this be used as a preventative medication to block COVID-19 virus from latching onto those host cells, much like the treatments for rheumatoid arthritis, severe asthma, or other diseases? And secondly, would preventative medication options like this help complement the effectiveness of a vaccine once it's available?
Yeah, so
Yes
thank
and
you
no.
for that question, Senator Rosen. That's an excellent question. And in
It is an
all
excellent
of
question.
the therapeutic interventions that we are developing, and you mentioned several of them, they could be direct antivirals along the line of remdesivir, but that's just one of the number of
Remdesivir.
possibilities, since there are several viral targets in the replication cycle. Using convalescent plasma in a preventive modality, as well as monoclonal antibodies in a preventive modality, are in fact all feasible and will be pursued in parallel with the development of a vaccine. The model of using drugs and other interventions that are effective for treatment is really a great success story in the issue with HIV/AIDS, because many of the interventions that were developed for the full treatment of an infected person are exquisitely effective in preventing infection of HIV. So that's the kind of model that we work out in parallel with treatment for disease. It's the using as treatment as prevention. I believe that will be a part of our effort at the same time as we're putting a full court press on trying to get a vaccine. So it's an excellent question, very relevant.
I know I have a short time left, so I'm just going to kind of abbreviate this. The second most important question that I
just
get,
not
just from our first responders and people worried about work, but generally, what does the next generation of PPE need to look like for all of us as we go about our lives, not just as workers? Depending on your work, you may need something stronger, more specific, but as all of us, as we want to go out and shop or out to eat or whatever those things are, get on an airplane, should masks be made of a certain material? Gloves, are handkerchiefs effective? Can you talk about PPE for the general public?
And also, what model of droid
the
is
best
this?
PPE for the general public, if possible, right now, is to maintain the physical and social distancing. But as we've said, and I think all of us would agree, there are certain circumstances in which it is beyond your control when you need to do necessary things,
like get a tattoo,
go to the drugstore and get your medication, go to the grocery store and get your food, that in fact you need some supplementation to just physical distancing. And that's the reason why some time ago, the recommendation was made, I believe it was Dr. Redfield at the CDC who first said that, about getting some sort of a covering. We don't want to call it a mask because back then we were concerned we would be taking masks away from the healthcare providers. But some sort of mask-like facial covering, I think for the time being, should be a very regular
Fauci just doesn't mind the truth, even when it's damning.
And in fact, the more and more as you go outside, right here and where I'm sitting in Washington, D.C., you can see many people out there with masks on, which gives me some degree of comfort that people are taking this very seriously.
Thank you.
Houston, DeRozan, Senator Loeffler.
Thank you all for being here and for your
That
service.
was Loeffler.
Admiral Giroir, before I start my questions, I want to recognize your new role as the U.S.
Before I start my questions, I just had a couple of stock trades to complete.
Mitigating a resurgence of this pandemic will take global cooperation. In order to do that, we need accountability and transparency at the WHO.
I just have my Robinhood app open right here. Could you tell me, will more people die from the
unbiased information on global health emergencies just as this? Reforms must be made in order to restore the trust that we need here. I hope you'll work with our allies to push for these reforms. This question, I have two questions. The first one is for Dr. Redfield. And Dr. Redfield, Georgians are wondering how we got here today. 1,400 deaths, a third of Georgia's workforce out of work. I'm incredibly concerned about the cover-up and the misinformation coming from China and their efforts to suppress life-saving information at the outset of this outbreak. As we continue to reopen our economy safely, we have to take steps to ensure that another outbreak cannot take hold of the world in this way. I understand CDC has worked with the Chinese CDC on global health security for decades. Can you comment on the level and the timing of the information that you received and relied upon from your Chinese counterparts as this virus emerged?
And why Trump pulled out
you very much, Senator.
the American
I
who was monitoring.
How important global health security is as a national security priority for this nation, and we're going to need to be able to respond to that as long as we are a nation. CDC has had relationships with many countries around the world. We have offices in over 45 countries right now, people in over 60. And one of those happens to be China, where we have a U.S. CDC that's with the Chinese CDC. We've worked together for decades, particularly on influenza and emergent infectious diseases. And that has been a very productive, collaborative, scientific interaction. When this original outbreak of pneumonia of unknown etiology came from the original seafood market, there were obviously discussions with the U.S. personnel that were engaging with the Chinese CDC. I personally had discussions as early, I think CDC did as early as January, and myself January 3rd, with my counterpart to discuss this. So at a scientific level, we had very good interactions. I think that's different than the broader Chinese government level.
Thank you, Dr. Redfield. I have a final question for each of our great witnesses
did not go
today.
down that road
It's
she
one
wanted her to.
My constituents often ask me. The mainstream media and indeed some of my colleagues in the Senate seem to want to paint each of your relationships with our president during this wartime effort as confrontational and lacking consensus. Can you categorically say here to the American people today whether this is true or untrue? From your testimony today, I've seen a very coordinated effort to address this with the administration to combat this pandemic. Can you give me a sense of whether what the characterization is whether it's true or untrue? Thank you. I'd ask Dr. Fauci to answer that first.
Is she with OAN?
Yes. No, there is certainly not a confrontational relationship between me and the president. As I mentioned many times, I give advice and opinion based on evidence-based scientific information. He hears that, he respects it, he gets opinions from a variety of other people, but in no way, in my experience over the last several months, has there been any confrontational relationship between us.
Well, that's important. Relationships.
Thank you, Dr. Redfield, Dr. Hahn.
Again, I would echo what Dr. Fauci said. We're there to give our best public health advice.
He's probably tweeting about it already.
And that's what we do. It's grounded in data and science. And I've always felt free to give the best public health advice that I think needs to be given at the time, and it's always been done in a very professional way.
Senator Loeffler, this is Steve Hahn. I do not have a confrontational relationship, have not had a confrontational relationship with the president. He asks questions. I have given him my honest answers rooted in data and science, and he has listened respectfully to those, incorporating that into his decision-making.
And Brett Joie, I have nothing else but to echo my colleagues. We work very closely together, all the scientists, all the physicians, of course, Ambassador Birx, other scientists within our group. We have a very productive working relationship with each other and also with the president.
Oh, he took the plastic off the camera.
It would not be confrontational, and I certainly feel that we have the ability to honestly state our opinions and recommendations, and that's been that way since the beginning.
Thank you, Senator Loeffler. Senator Murray, do you have closing comments?
They might rule in favor of Trump.
I have two quick questions.
Sure.
Well, thank you. Dr. Fauci, while President Trump claimed otherwise, there is no question.
They're now on their second round of questionings for Dunn.
Our economy safely is successfully developing and distributing a vaccine.
Just pauses for a second. So, Alito asked Dunn, is the undue burden in Clinton versus Jones, does it become an undue burden because of what happened afterwards? In other words, Clinton had to go through impeachment, and that took a lot of his time. Now, the argument, there are two things. Number one, he was still able to fulfill his duties as president after that point in time. It didn't damage him at all, really. And the second argument, which is what Dunn apparently answered with, is that the only reason it became burdensome to the president is because he lied in his deposition. So as long as the defendant is honest, and this isn't even testimony. I mean, I would just argue it's like it doesn't even apply in this case, but they're trying to set standards. They're trying to set precedent with what they're doing right now. So, but Dunn gave a good answer.
Vaccine for COVID-19. We need to plan now to deploy a vaccine once it's proven safe and effective. But it is absolutely crucial, this planning process, from the clinical trial to distribution.
Yeah, I don't have any confidence that the SCOTUS is going to rule one way or the other but Roberts has shown himself to be fair before. Alito seems to be getting the answers they want. I haven't heard anybody setting up Dunn for softballs, but they are asking for clarification. The other thing is that they're giving him double the time of the Trump lawyers, because there's two Trump lawyers in both of these cases, and just one, in this case, Dunn, as opposed to the prosecutor, the congressional attorney in the last case. They're both getting double time, so that they're hearing equal time arguments from both sides, which is nice. I mean, it should be that way, but again, if it was a rigged process, they could cut down on that. Patty Murray.
recognizes and addresses racial and ethnic disparities in our healthcare system that, as we all know, for too long have been overlooked and unacknowledged in this country. And we have to ensure equitable access.
Let's skip ahead to
keep
live.
their patients and communities safe. And while experts have been clear that the day we can safely reopen may be a ways off.
I hate it when the senators just get on there and read. You've got expert witnesses. Ask them questions.
If an effective vaccine, we can produce and distribute it to everyone quickly.
Everyone says this is about getting sound bites, but honestly, how many people pay attention to this? What was it going to be, 2 seconds in a political ad? It's a waste of everyone's time.
Presented by.
And she's my senator, by the way.
Physical isolation, loss of income, to the trauma and anxiety of patients and workers who've been on the front lines. So I'm going to keep pressing Congress and the White House to provide the action and leadership that our community.
Okay, I answered my own question. You know who watches these? Fundraisers and donors. So, yeah, this is why this is happening. People so passionate about politics that they spend time donating money as opposed to live streaming 2 concurrent federal events.
Thank you to all of you for joining us today.
Thank you, Senator Murray. I've got a clarification question and a couple of quick comments, and then we'll thank the witnesses and wind up the hearing. My clarification is I want to make sure I didn't create some confusion. By the way, I asked the question about going back to school. I asked Dr. Fauci first about treatments and vaccines, and Admiral Giroir second about testing. What I thought I heard was that Dr. Fauci said that vaccines are coming as fast as they ever have, but it'll be later in the year at the earliest before we see that there's some treatments that are modest but are promising. There could be more, but that doesn't mean you shouldn't go back to school. That would be more for a testing strategy. Am I right, Dr. Fauci? You didn't say you shouldn't go back to school because we won't have vaccines by the fall.
No, absolutely not, Mr. Chairman.
It's over. SCOTUS is
is that going back to school
Hold on. Is this
would
a
be
replay?
more in the realm of knowing the landscape.
Fauci, you pause for a second.
The DA has, under state law, adds to the president. The Second Circuit is wrong and should be reversed. If not reversed,
yeah, this is just replay. This is what Sekula was saying before. So yeah, okay. So SCOTUS is done. Let's go back to. You be quiet. Just the way all the Trump surrogates talk. Like, there is absolutely no way that the Second Circuit should be allowed to Like, if one of these people's in real life talking in real's life, I'm gonna stop talking. That's just a replay. I think they're just showing the replay of that portion because it looks like they are done. I'll click over here while you guys are watching this.
Landscape of infection with regard
I only
to
have
testing.
4 computers here.
And as Admiral Giroir said, it would depend on the dynamics of the outbreak in the region where the school is. But I did not mean to imply at all any relationship between the availability of a vaccine and treatment and our ability to go back to school. You're quite correct.
And what I heard from Admiral Giroir was that you're ramping up current technologies. You are hopeful for Dr. Collins' Shark Tank and the National Institutes of Health.
Thanks, Kara.
That, you would expect to have the capacity in the fall of 40 to 50 million tests a month. And that ought to be adequate for the principal of a middle school or even the chancellor of a campus to design a testing strategy that could provide, for example, an antigen quick test to screen all the students in the school if necessary. Is that correct?
Yes, sir, Mr. Chairman. And again, we
if
want
it's available,
to make as many tests available as absolutely possible.
27 million by the end of March.
What I feel comfortable with, knowing the production schedules, being in the position of being able to work with the FDA and CDC, that we should have 40 to 50. We will have 40 to 50 million tests available per month, need to be deployed in a smart, strategic way, depending on the dynamics, in that area and in that region. Still, having testing even widely does not nullify the need that we're going to have to change our practices in terms of sanitation, personal cleanliness, distancing, face masks.
So you test the kids going to school in a hotspot. Don't send the kids to school if it's a hotspot.
Things like that, given what the dynamics could be.
Well, thank you for those comments, because given that number of tests that will be available in, say, 3 months, or
he's got a dog
ramp up to that number 3 months from now.
Okay, it's okay with
every
me.
Principal,
look at that good boy. Who's a gooder? Who's a good boy?
Chancellor of every college campus, and again, we have about 5,000 campuses and 100,000 schools. Some reassurance that testing, as well as the common sense hygiene practices you talked about, could be used to develop a strategy for reopening school in August. And then 2 quick comments. One is Senator Murray talked about the national plan, which was in the legislation that we all voted for. There's a little bit of a push and tug between what's national and what's federal, what Washington should do and what the states should do. I've always thought it's a mistake to say federal equals national. In other words, COVID-19 is clearly a national problem, but that doesn't mean the federal government's supposed to do everything. For example, in testing, the law actually requires states to tell you, Admiral Giroir, what their plans are, what their needs are. And then you said that during the month of May, you had a series of state plans that identified 12.5 million tests, and you thought you could help meet that. On the other hand, you've also noticed a deficiency in the marketplace for some supplies, so the federal government is buying those and allocating them to the states. So we don't want to get in a situation where Admiral Giroir is telling all the states what to do. Governor Lee in Tennessee doesn't really want you to tell him what to do. He wants to tell you what he's doing and let you comment on it. I don't think Governor Cuomo wants President Trump telling him what to do. So a push and
nobody
tug
wants
between
President Trump
what
telling
Washington
him what to
does
do.
and what the states do. I think we have a testing,
We'll just let it
contact
just
tracing,
wave over.
isolating,
It'll disappear.
national strategy and plan led by the governors, designed by the federal government as a national effort. And then the national effort clearly is to do the research for the treatments and the vaccines. And what we've heard today is that's coming along on a faster track than we've ever seen before. Finally, I want to reiterate, I thought this was a very helpful hearing. I
think we're wrapping up here too. Yeah, he's just doing his closing statement. I just want the dog to move.
Diversity of opinion.
That's all I care about
and
at
the
this
honest
point.
answers we got from 4 really remarkable experts who are in the midst of this every day. I want to reemphasize what I said earlier, that I intend to make sure that we focus. Senator Murray suggested we need to have more hearings. I agree with her. And as we deal with this pandemic, we need to make sure we're ready for the next one. What can we learn about faster treatments and vaccines for the next one? What can we learn about the stockpile? What ought to be in it? Who ought to be manage it for the next one? What can we learn? Can we learn anything about having hospital beds so we don't have to shut down hospitals and bankrupt them and
Who's a good boy?
push patients
Who's
out
that good? Who's that good boy? Who's that good boy? Who's that good boy?
sick people from the pandemic? What about states and hospitals that sell off their PPE in between pandemics? How do we keep our focus in between pandemics when we have so many important things to be worried about in this country? How do we make sure that we in Congress
in the pauper's defense, I would be so bored if Lamar was my master as well.
And I want to make sure
sleep
that
all
we
day.
do that this year. I mean, our collective memory is short. So while we're all worried about this, we need to not only deal with this crisis, but get ready for the next one. I thank the witnesses for their extra time.
Lamar has no color photographs.
We see is to create an
the only
environment
color he
in which
has
you
is
can
the
succeed,
painting.
because if you
Lamar
succeed,
lives
our
160
country
years ago.
Succeeds, which is what we desperately want. The hearing record will remain open for 10 days. Members may submit additional information for the record within that time if they would like. Thanks to everyone for being here today. The hearing is adjourned.
Thank you very much, Mr. Chairman. Thank you, Senator. I'm John King in Washington. You've been watching the Senate Health, Education, and Labor Committee, a 3.5-hour hearing, just shy of 3.5 hours. The senators questioning 4 top Trump administration officials about the coronavirus response. A remarkable hearing, including Dr. Anthony Fauci.
They're going to show some highlights, so why don't we stick around for a couple minutes?
That if states are not careful,
we must have
as
missed
the country
something.
now begins to reopen, just about every state by this weekend will have at least a limited reopening plan in place. Dr. Fauci warning that if they are not careful, if they do not follow administration guidelines, if they do not have testing, contact tracing, and other steps in place, there is a risk to trigger a resurgence, another outbreak of the coronavirus pandemic. Also, Admiral Brett Giroir, the top testing official, saying he is confident that by the end of May and into June, they will have more tests available. By the time schools are supposed to open in the fall, he says he is confident there will be enough testing to reopen schools. A great deal of skepticism from Democrats and Republicans on that front. Actually, what was remarkable, Democrats saying they think the scientists are separated from the president quite frequently. Democrats harshly critical of the president. But what was remarkable was a number of the Republicans, a number of the Republican senators, more gently than the Democrats, raising serious concerns. Richard Burr saying the CDC has not used money it was given last year before the pandemic to hire key surveillance trackers to track such things as the coronavirus. Wow. Senator Cassidy of Louisiana saying he is not convinced there is a specific testing plan in place to allow schools to reopen, especially in underprivileged areas. Senator Mitt Romney harshly critical, saying the testing record of this administration is nothing to celebrate, saying that in February and March, time was wasted and lost as the coronavirus spread across the country. Let's get some insights from our guests here. With us, our Chief Political Analyst, Gloria Borger, our Chief Medical Correspondent, Dr. Sanjay Gupta. Also with us, Dr. Ashish Jha, who's the Director of the
we're not going to watch this whole thing.
Let's see. Sanjay, I want to start with you, and I want to tee it up with
what's going on at the MSNBCs.
Who we know he has been cautious behind the scenes.
We just got Chuck Todd. Oh, here we go. We're doing highlights.
By several sources.
Given that it is without a doubt that there will be infections that will be in the community.
Let's go back to the beginning of Fauci here.
The economy and
so they're showing the highlights. So we'll catch what we didn't miss here. Hold on. There we go.
Fauci testified that some of the lines are going in the right direction, but they're not there yet. As you alluded to, this was mostly a virtual hearing. The chair of the committee, Lamar Alexander.
We're just watching a replay from February when everyone was like, hey, we should test. We should get our act together so this doesn't become an outbreak.
He specifically had questions for Fauci about reopening colleges and schools in the fall. Dr. Fauci was skeptical. Listen.
My concern that if some areas, cities, states, or what have you, jump over those various checkpoints and prematurely open up without having the capability of being able to respond effectively and efficiently, my concern is that we will start to see little spikes that might turn into outbreaks.
Now, Fauci testified there have only been what he termed modest successes when it comes to developing therapeutics to treat coronavirus. With the vaccine, Fauci told senators we hope to know more in the fall or early winter. He also said that there are multiple candidates
I know she's 6 feet apart, but she's in an enclosed space as well.
But
the 6 foot rule doesn't apply indoors.
There's no guarantee a vaccine would be effective. Concerns linger about reopening the economy and the government's response.
If we do not respond in an adequate way when the fall comes, given that it is without a doubt that there will be infections that will be in the community, then we run the risk of having a resurgence.
I wish we could tell the American people that the federal government has this pandemic under control, but we can't. In fact, you have said that the virus is not under control in the U.S.
There was criticism of the panel from...
Who's that whippersnapper, and why hasn't she run for president?
Democratic Senator Christopher Murphy, a Democrat of Connecticut. He thought that some of the advice that the witnesses, the doctors were giving about reopening the economy was vague, criminally vague. That's the term he used. Harris, back to you.
Wait, who used that term?
Chad. Christopher Murphy, a Democrat of Connecticut.
Oh, okay.
He thought that some of the advice that the witnesses, the doctors were giving about reopening the economy was vague, criminally vague. That's the term he used. Harris, back to you.
All right, Chad, thank you for giving us a little
quite
taste
frankly,
of what
Chris,
those
I'm
3 hours were
disappointed
like. Very
that she's not
spirited,
wearing
as
a
you
mask.
said, at times. Sober points were...
It can be senators talking and you can say, I'm in a really bad primary and need to show my MAGA stripes in this, so I'm going to bleat about this stuff. Or I'm from a state where I'm a white senator with a large minority population, so I need to bleat about this stuff. And so much, of course, of these hearings is flummery, right? Because it's not
it
about
is
getting
flummery.
Answers. It's about
Fox
posturing.
News guy is right.
Now, much of this hearing was quite good. Much of this hearing was quite revealing. I thought that the way Fauci dealt with Rand Paul was very indicative of his overall approach, which is he tries to be humble, he tries to go easy, go slow, and when you have somebody like Paul, the guy who brought the coronavirus to the Republican Senate lunch, scolding him about thinking he knows everything, Fauci could have gone right for that and said, "Why didn't you wear a mask, bro?" But he didn't. He was calm and measured. That's why people look to him.
That sounds like Fauci.
He does keep it.
Why didn't you wear a mask, bro? Okay, that's what are we at? We're at 10:30 already in the morning, which is like 4:37 on the East Coast. So I'll wait a couple seconds here for the chat room to catch up, but I think I'm going to shower and get my day going here. Or not shower. Maybe I'll take a nap. I was up at 5 this morning. Ridiculous brain. This whole thing is an undue burden on me, so I need this virus to stop. You guys all have a good day. If anybody wants to comment on anything, any way, shape, or form, now is the time to do it. I'm going to come back later today. There's other stuff going on. I'm on a podcast tonight, and I don't know. I think it's going to be recorded. Silas, if you're watching, we're recording tonight, right? I have no idea if Silas is watching. Anyway, so I'll be on a podcast. I'll let you guys know about that later. Doesn't look like anyone's watching. This was a marathon, guys, so I really appreciate those of you who stuck it out. Not everybody did. Hey, Patricia. Okay, Patricia's still here, so thank you, Patricia, for hanging in there with me. Supreme Court arguments were interesting, and it's kind of cool to hear that going on real time, because usually we just get the synopsis after the end, or sometimes we'll hear a little bit of recording, but it was kind of cool to see that happening real time. I can't call it. No, don't apologize, Green Room. You do your life. I mean, I was in and out as well, so. And now I'm debating, do I take a nap or do I have more coffee? I don't know what to do with that, because I just had 1 cup this morning to get up. This is not a good look on this guy. I'm going to just press play. Cool. There we go. That's better. Hey, guys. It's been, I'm going to say fun, but it was, I don't think we learned anything in the congressional hearing. Maybe we did. I don't know. I don't know that anything happened that's going to change anything. Nothing that happens nowadays seems to change anything. And I'm just completely befuddled that whether people should live or die comes down to party lines. And it really doesn't. 75 to 80% of the American people are saying, hey, let's not rush things. We've been doing the quarantine thing. I'm still not done with every episode of Breaking Bad. Let's just, I should have said Tiger King. That's a little more topical. Rewatching Breaking Bad. In my case, Billions. Let's slow our roll and go about this cautiously. But you've got the bases on both sides, and that is what the party system is all about. You're 20% of diehards over here, and you're 20% of diehards over here, and your remaining X percentage of people in the middle that either don't care or are just like, stop, you people. I just want to be alive. So that's the end of that. My voice is starting to go, even though I didn't talk a whole lot in this anyway. Guys, be safe. I'll do a Billy Joel update later in the day. Hey, while you're here, in case anybody cares, no one's here. No one cares about Billy Joel right now, so you can go look for yourself. If you haven't voted in Billy Joel Madness, go on my Twitter page and actually just hashtag Billy Joel Madness, and you can find the votes. And there's 4 votes that are up today. So if you're a Billy Joel fan at all, go vote in those 4 votes, or 3, or 2, or not at all. That's fine. I think I'm going to have a hamburger for lunch. I bought some hamburgers. I've got some online shopping to do. I'll check in and see that my unemployment claim is still denied. Maybe I'll call unemployment and wait on hold. I have the podcast at 8 o'clock, so that gives me 9.5 hours to be on hold. Probably not enough. I should wait till tomorrow. Hey, you're welcome, Stephen. Thank you. Cheers, guys. Have a good one. Love you, mean it.